anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. That seems to work. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Shin. To my left, Justice Singh. We are your panel for this morning. We will be hearing 6 cases. The rules are, as they always are here if you've been here before, 15 minutes aside. There is no rebuttal. If either side is dividing its time among parties, let us know in advance. We already have some notice in at least one case of that. We have read your briefs with care and are familiar with the facts, so you may want to get right into your argument because it's not much time. On the other hand, the time is yours to do with as you like. And with that, we will hear our first case of the morning, which is number 25844, Joe versus Lynn. And we will hear first from, you'd think I would know the answer to this, although it's awfully hard to tell from what I've been given. It looks like we will hear first from Attorney Martin.
Yes, Your Honor.
Is that right?
So, good morning, Your Honors, and may it please the Court. Your Honors, Rule 6I exists for cases just like this one. The appellants have a strong likelihood of success on the merits of this case, especially with respect to this remedy, and there's no rush to reinstate plaintiff, as she herself tacitly conceded by never seeking preliminary injunctive relief, ordering her reinstatement during the 7 years this case was pending below. Since the single justice only addressed the likelihood of success in the merits factor, I would like to go there first.
Can I ask you a preliminary question about jurisdiction? So now we have this second appeal from what you're calling a preliminary injunction. It's now been docketed.
Correct, Your Honor.
Doesn't that present the exact same issue as what we're deciding?
I mean, right now what you're deciding is whether to stay the injunction pending that appeal. It will actually get more complicated if and when final judgment finally enters.
I'm sorry, pending which appeal?
Pending the, so there was effectively a preliminary injunction entered below. Mm-hmm. So we have noticed an appeal from that. That notice of appeal is at Joint Appendix 670.
Notice an interlocutory appeal to the single justice?
Correct, under 118.
Okay, and the single justice did what with the merits of that appeal?
Nothing. He
You don't
rejected.
think he dismissed it?
He dismissed the appeal under 118.
Okay, so what are you seeking a stay pending? That can't be reinstated because it's not reviewable.
Well, no, Your Honor.
So what would the point be of a stay?
He dismissed the appeal under 118 first paragraph. There's also a notice of appeal at 678 to 679 under 118 second paragraph.
And that's what I'm asking about. And doesn't
Right.
that appeal present essentially the same question as this appeal? Shouldn't the appeals be consolidated? I mean, whatever we decide today, that appeal's not going to go forward, right? Or not today, well, whatever we decide in this
Presumably,
appeal.
whatever you decide today will have, it's hard to imagine someone reaching a different decision on that, except that there are stay factors which apply to this appeal that do not apply to that appeal. To the extent you're addressing the merits of the case, it's hard to imagine a different outcome, except that we intentionally limited ourselves in this appeal to the material that was before the single justice.
So should the appeals be consolidated then? Because, I mean, normally what you would see is that appeal, the motion for a stay would be filed under that docket number, right?
Nope.
So if the motion for stay was filed under that docket number, and then single justice denies the motion, and then there's another notice of appeal, it'd be under the same case.
I mean, in essence, we have no objection to the procedural to that procedural posture. What's important to us is that we asked for a stay from the single justice. We asked for a stay pending this appeal as well, which was referred to this panel. We're looking for immediate relief from the decision below ordering plaintiff's reinstatement, which we view as fundamentally legally flawed for at least 2 reasons, which are addressed in our brief. And I'd like to start, for example, with the lack of findings below. Right, we have effectively a preliminary injunction, which will convert into a permanent injunction.
I thought 60 days or 90 days after something happened, it was supposed to do that. But I gather no final judgment has ever entered below, even when those days passed. The judge extended it by 30 days or something. But that time has long since passed. Am I right?
That is correct. So the
But
plaintiff,
there is no separate judgment. There's no sheet of paper that says, here's your judgment. in the
right.
case.
Right now, the reinstatement order is acting as a preliminary injunction. It's a preliminary injunction where there was no discussion of the equitable factors below. There were no findings of fact concerning the equitable factors. It's hard to imagine a preliminary injunction, or once it converts into a permanent injunction.
And what is the difference between a petition under paragraph, I think you said 1 of 118, and an appeal under paragraph 2? And why was the stay application presented with the petition rather than with the merits of the appeal?
It was presented in the alternative, Your Honor. And by the time it was presented to the single justice, there was a notice of appeal, the notice of appeal at 678 to 679.
And what is the difference
Under
between a
paragraph
petition under 118 and an appeal, paragraph 1, and an appeal under paragraph 2?
An appeal under paragraph 2 is reviewable by a panel of this court. A single justice's decision under paragraph 1 is not.
An interlocutory appeal of a preliminary injunction to this full court is permitted? That sounds interlocutory to me.
It is interlocutory, Your Honor. I mean,
I thought injunctions were appealable, or denial of injunctions, either way, were appealable to the single justice. Am I mistaken about that?
An appeal under paragraph 1 is. An appeal under paragraph 2 is not. I mean, certainly there's been no suggestion that our notice of appeal under paragraph 2 is subject to dismissal. In either case, Rule 6I, what we're here for today, specifically allows a panel of this court to consider an appeal from a single justice's order denying a stay pending appeal. And so this court certainly has jurisdiction to consider our Rule 6I motion appeal. Going back to the merits, right? We have a preliminary injunction with no findings, no conclusions of law, no discussion of the equitable factors. Under decisions like Brody, Pointer, Doe versus Weston, it is impossible to imagine this reinstatement order surviving on appeal. The repeated lesson from this court and the SJC is that equitable relief requires a discussion of the equitable factors and requires findings concerning the equitable factors. Once this reinstatement order is before the court on the merits, I have a hard time imagining it surviving. And that's even putting aside the waiver issue, right? There was no discussion of reinstatement as a remedy after it was pled in the complaints in 2018 and 2019.
So because we're reviewing for abuse of discretion by the single justice, we would have to find that there's no way the single justice could have concluded otherwise, right? So if it's debatable, then it wouldn't be an abuse of discretion.
It has to be an error of judgment. We think here there's an error of law, right? As a matter of law, you cannot have an injunction that is unsupported by a discussion of the equitable factors and unsupported by findings. Orders like that are routinely sent back by the SJC. They're at least vacated by the SJC in this court, as in the cases we cited and that I just mentioned. And so we think it was an abuse of discretion, A, for the Superior Court to enter an injunctive order without undertaking the necessary analysis, but then B, also for the single justice not to recognize that error in the decision below and to therefore stay the reinstatement order pending an appeal on the merits. And this was an issue. We're not in any way, like, for example, sandbagging the trial court judge. The lack of necessary findings was specifically referenced by trial counsel in the motion for reconsideration that was filed soon after the reinstatement order was entered. And the Superior Court specifically said, I am not entering more findings. There were no further conclusions of law concerning the equities that were made below. And this was again brought to the lack of findings below was specifically brought to the single justice's attention. And we don't know what the single justice thought about all of this because it's simply the one-line discussion finding that we lack the likelihood of success in the merits. But so under those circumstances, we think the only way to approach the analysis is to focus on what the errors were below and point out that they were bedrock errors of law. We're not talking about wading into the facts of the case and asking for reconsideration of witness testimony. There are two things which are absolutely clear. One, you need a discussion of the equities and you need supporting findings. And two, if a legal issue, if a remedy has not been presented by plaintiff who...
Well, it was presented. It was in the complaint.
It was only in the complaint, Your Honor. And that's actually...
Why isn't that enough?
It's not enough, because you have to show at the end of the day that the equities support the remedy. And here, if you look back, I realize I'm not in the record, we've said this in our brief, and the other side has not contested this. If you look at the pretrial pleadings, if you look at the joint pretrial memorandum, if you look at the proposed findings of fact and conclusions of law, there's absolutely no discussion by plaintiff of reinstatement, of the equitable factors. There's no request for findings that go to the equitable factors. Was not mentioned during opening statements, was not mentioned during closing argument. It simply did not ever come up during trial. That, under decisions that we cited like M.B. Claff and Slade, is a waiver of the issue. Certainly the Superior Court does have equitable discretion to enter the remedy, but the equitable discretion has to be based upon an argument made by a party, right? The court cannot come up with effectively a argument on its own at the end of the case as to why a certain remedy should be entered, and that's what happened here.
But isn't the question here, since it's abuse of discretion by the single justice in deciding that there was no, or that there was not a likelihood of success on the merits, we would have to find that it was beyond the scope of the single justice's discretion to conclude, for example, that even without that, a reviewing court would look at this and look at the equities as they are presented in the record and conclude, yeah, that sounds right. And that's a pretty tall mountain for you to climb.
It is a difficult standard, Your Honor, but Rule 6I exists for a reason. There will be cases where the single justice simply got it wrong, and we believe this is such a case. And again, this is not a case where we're asking the court. I assume you see lots of these things, and a lot of them are just meritless. That's not this case. We have two legal errors. They should have been errors that were clear from the face of the papers that were before the single justice. The lack of findings, especially, is one where we should at least get vacator on that, and we think we should get reversal based upon the waiver. Those are two clear legal questions, and I think this panel certainly has the discretion to find where there's not an explanation from the single justice as to why he concluded there was a lack of likelihood of success in the merits, that this is the sort of case where the status quo that existed from 2018 to 2025 should be preserved, particularly where plaintiff herself, I sort of can't get my mind around this, never asked for preliminary injunctive relief reinstating her during that 7-year period.
She asked for injunctive relief, and you are calling it a preliminary injunction. I understand why, because there are pieces of the case that either are left or at least no final judgment is entered. But she asked for injunctive relief. How do I know? I read the complaint. So, I mean, I hear what you're saying, but I'm not knocked out that it's obvious this was waived. That's the relief she sought in the complaint.
Your Honor, if a complaint said, we asked for injunctive relief, and then at no point was a motion for a preliminary injunction filed, a superior court could not simply enter
You're calling it a preliminary injunction. I'm saying, effectively, it's a permanent injunction. I understand why it's interlocutory and why, therefore, as a technical matter, you say it's a preliminary injunction. I'm not saying that's wrong. But I'm saying this wasn't a week into this, quick, I need a preliminary injunction. This is effectively a permanent injunction. In fact, a final judgment was supposed to enter, again, it's 90 days or 60 days, something after.
So, Your Honor, if it's a permanent injunction, in some ways that's even worse, because under Rule 52A, a trial court judge, sitting as finder of fact, is required to specifically enter findings of fact and conclusions of law.
But if a reviewing court found that any error in not doing the findings was harmless, then they would affirm that injunction, right? And given the facts of this case vis-a-vis the conduct of your clients, someone could find that.
Your Honor, when it comes to the specific remedy, right, and in this appeal we're only talking about the remedy, not the rest of the case, I think a reviewing court could not find that it's absolutely clear and harmless to put a plaintiff who has not been at the company for 7 years back into all of the key leadership positions in the company without at least some analysis and findings concerning the equities of doing so. We think a reviewing court could not reach that conclusion. We talk in our brief about the discord between the parties, which could impact her reinstatement. We also talk about, and I really didn't see a response to this.
That's why the judge, in response to your motion for reconsideration, ordered the appointment of 2 independent directors precisely to address that problem.
She did. We don't think it actually, again, there's no analysis and no findings on this, and the single justice didn't specifically address it. But there's also the problem that she hasn't even been at the company for 7 years, right? We cannot find a case where someone has been put back into a company at all, much less into all the senior leadership positions after such a period of time. If a superior court is going to enter such an unprecedented order, then you would at least expect to see some consideration of the equities of doing so. And we know this is important because in cases like Coggins and Pointer and Brody, when there's not a discussion and specific findings about the equities of putting somebody back into a company or unwinding a transaction, then the case is sent back down. It gets vacated and sent back down for further proceedings. And that, we believe, is the appropriate outcome in this case.
Before you run out of time, could I just ask you about the balancing of the harms, which I find pretty perplexing because the status quo today is that she's been reinstated, right? So you say that the reinstatement doesn't moot the appeal because the order has, the injunction has ongoing effect while the appeal is pending, but yet your arguments about the harms all seem to focus on the harm from her being reinstated. But now that she's already been reinstated, don't you need to show that there's irreparable harm from her reinstatement continuing? In other words, so that your clients don't have freedom to fire her? Isn't that what we're deciding?
In effect, yes, Your Honor. We believe we've already been harmed by her presence back at the company, and we believe her ongoing presence at the company, without the board of the company, including as reconstituted, having the ability to remove her if it decides that it needs to do so, imposes additional ongoing harm. And this would be going outside the record, so I would do so with the court's permission. But we could talk about some of the things that have been happening at the company.
Why don't we not go outside the record?
Okay.
I mean, for instance, the fact that she didn't seek a true preliminary injunction for the years that this case was pending, I would find that pretty significant if this was coming to us as a traditional review if this was coming to us in the posture that it was when the order was entered. In other words, now that she's been reinstated, all of the equities have changed.
Yeah, we don't believe they have, Your Honor. Right now, we are bound by the reinstatement order from removing her, even if we believe it's in the best interest of the company to do so. And so that both shows why the order is not moot and shows the importance of removing the order so that this board can act like the board of any other company and decide whether to keep someone in senior leadership, even if they are doing things which are viewed as contrary to the interests of the company. And so with that, Your Honors, we would request that you restore the status quo by staying the reinstatement order.
Thank you very much. Your time has expired. Very good argument. We will hear next from...
Thank you, Your Honor. Patrick DiNardo representing the
plaintiff
appellee. Patrick DiNardo representing the plaintiff appellee, Majo. And I appreciate the court's focus on the point about jurisdiction. It is technical, but it disposes of the case because this limited issue for today is whether or not the single justice, as Justice Shin wrote in her order on 7/29, the limited issue of whether the single justice abused his discretion in denying defendant's motion for stay. That's the only issue for today. And there's absolutely no abuse of discretion. They say that the single justice gave no explanation, but he did. It's just an explanation they don't like.
Here's the jurisdictional. You started with jurisdiction.
Yes.
Why is there no jurisdiction here? Your friend on the other side says there's a pending appeal under paragraph 2 of 118 to the full court.
Well,
you can seek a stay pending that.
Because the motion for stay was appended and ancillary to the original petition under paragraph 1. And when that was dismissed, the motion, the ancillary motion, the jurisdiction on the ancillary motion went with it. And as I said, it's a technical argument, but it's in fact what the law provides here.
Well, is there anything, so you don't dispute that the appeal under paragraph 2 is proper?
Well, they've made an appeal under paragraph 2.
I don't see anything that prevents them from filing a motion for a stay while that appeal is pending. I mean, it's a little strange, but
It is strange, and it's death by 1,000 cuts. They can't accept the fact that they lost after a 24-day trial, and they are trying everything possible to
well,
spend
that's
our
not what I'm
client into
asking.
oblivion.
If the other appeal, 25P1107, were before this panel, we would certainly have jurisdiction over that, right?
Yes, and that's going to be briefed in the next few weeks, and I'm sure we'll
Well,
be
it
back on that.
seems like it's going to be precluded or mooted by whatever we decide in this appeal. That's why I was asking whether the appeals should really be consolidated.
Well, I think this appeal is moot, and we can deal with that appeal at the appropriate time. This appeal is moot, apart from the jurisdictional issue. This appeal is moot because my client's already been reinstated. The request here was to stay her reinstatement. That happened 3 months ago, and the sky hasn't fallen. She's gotten involved. She's rekindling the relationships that she created herself to build this company. And the notion that there are no findings or no equities to support the injunction, the reinstatement injunction, is nonsense. The judge wrote a 61-page decision, which she laid out all her findings and conclusions. And one of her findings was that our client had a reasonable expectation that she would have continued employment in a leadership role. And more specifically, she recited the email exchange with Mr. Gao, Defendant Gao, where he acknowledged she would have autonomy in running this particular entity, KL. And so it overstates the argument to suggest that our client for 7 years was on the outside looking in. In fact, the amended complaint was in August of 2019, and the case on the direct piece would have gone to trial in the fall of 23. Our firm got involved at that time when the attorneys for Meizhou decided to bring a second action on a derivative claim. And so that delayed the trial in 2023. But it wasn't a question of sitting on her hands for 7 years. In fact, she was monitoring the situation as best she could through discovery.
But she didn't ask for a preliminary injunction, which to me is pretty significant.
Well, she didn't ask for the injunction in part because it would have been futile. She was outvoted 2-1 on the board by her adversaries, and if she had taken over, she had tried to be reinstated at that point where a board was controlled by her adversaries, it would have been a fool's errand.
Well, why couldn't that be part of the remedy, a preliminary remedy?
Well, ultimately, it was. It was.
I mean, for 7 years
she didn't
later.
seek the preliminary injunction, but that doesn't preclude her. I'm not aware of any law that would say that would preclude her from seeking the permanent injunction
No, I'm
that
not,
she
and that's
requested
not
in
what
her
I'm saying,
complaint.
but it is relevant to the balancing of the harms.
Well, that's true, but I don't think we even get to that point because the first element of the test for them to show that they have a right to relief here is that they could show a reasonable likelihood of success on the merits. And they can't. After 24 days of trial, 318 exhibits, a very well-respected judge on the Superior Court made her findings and rulings, and part of the relief she thought was appropriate was exactly what the SJC contemplated in the Brody case, was damages and reinstatement. And the equities are apparent in that 61-page decision. There was a wrongful termination as part of a corporate freeze-out.
Do you disagree that the judge is supposed to go through and make findings with respect to the factors relevant to injunctive relief and that they weren't explicitly made here?
Well, I think they were explicitly made in the sense that the court found she had a reasonable expectation to continued employment in a leadership role. She made that finding, and she made that finding in conjunction with a finding that she was to have some autonomy in running the Knowledge Link entity that she built herself. This whole organization was started in 2009 with an entity called CIBR, Cambridge Institute for Business Research, and my client was convinced to come on board with her adversaries here to help use her passion and dedication to education for children in China who wanted to come to the U.S. to take advantage of the American education system. And then after a few years, it became apparent that there were difficulties bringing high school-age children to America for educational purposes, and it made more sense to let them stay at home where they would be in their home environment and bring the American education to them. And so my client spent several years visiting well over 100 partner schools in China. This is the work she did to create this entity. And they took that away from her because they didn't like the fact that she didn't agree with them on how the business was being handled. And so they had a pretextual firing as part of a corporate freeze-out. She had been making hundreds of thousands of dollars a year in distributions on top of her salary. All that stopped. And it stopped because the defendants made it stop by giving an unwarranted $2.4 million bonus to defendant Gao. So the equities are apparent from the record that Judge Squires-Lee laid out in her decision.
Wasn't the judge required to make findings about why the remedy is appropriate? And was there evidence presented on whether the equitable remedy would be appropriate?
The case was all about the rights and responsibilities that Meijo had and her rights to continued employment.
That was underlying the merits of the claims, but there is no evidence put in as to whether reinstatement would be appropriate. I mean,
oh, absolutely, Your Honor. The evidence was that the only way she could protect her 30% interest in these entities was by being there as and in charge of KL. Evidence at trial was legion about how much advantage the defendants had taken of this company and diverted opportunities to entities that are solely owned by them. The Shanghai Nolan entity was one of the primary
Why wouldn't damages be sufficient to make her whole? I mean, that's the question, right?
It's hard. If you're not on the inside and trying to stop these things happen as they're happening, it's very hard after the fact to try to put the pieces back together as to what's going on. And so the best way for Meijo to protect her interest in these companies is to be in a position to act on whatever decisions the defendants were trying to make happen. And that's why Justice Squires-Lee thought it was appropriate to have 2 additional directors appointed so that we'd have 2 independents, and that's imminent. They should be appointed, if not this week, within the next few weeks. And at that point, if they have issues with reinstatement, and not so much reinstatement, but Meijo's performance, they can raise those issues with that board. There'll be an independent element to the board, and if they have an argument to make about how they claim it's causing discord or she's not effective in her role, none of these arguments are going to carry the day with the independent board because, as I said, Meijo is the person who built this company, and it's a relationship company. It's based on the relationships with partner schools in China so that they will refer their students to the educational system that Knowledge Link is bringing to China. And those relationships depend.
Well, doesn't that really depend on what's left?
Well,
I mean, we have no idea, and it's whatever's happened since the orders issued is, beyond the scope of what we know about. We have no idea. If this has to be built from scratch, seems like maybe that's one thing. If these relationships are already destroyed, that may seem like another, like figuring out whether it makes sense to reinstate someone to a company that looks like it's been gutted.
That's why it's a decision best left
tricky.
to the board when the independent directors are aboard. They can make that call. Your Honor, I would submit that a lot of the revenues that KL earned today are based on contracts that were signed years ago. But maybe that's not in the record, and I won't go so far as to say that
Can
now.
I bring
but
you
as
back?
I said,
Can I bring you back to jurisdiction for one
Sure.
second? So I'm now looking at the petition before the single justice and the alternative request for a stay, and this says, and you can tell me if this is accurate or not. This says that Lin and Gao filed an alternative motion to stay compliance with the injunction until all appellate rights have been exhausted in the trial court, and that was denied, and that this motion also was until all appellate rights are exhausted, which would include presumably the already filed panel appeal. Do you disagree that that was before the motion judge, or the single justice?
Well, I think at the time, the only appellate rights they had invoked were under the first paragraph. So, as I said, I think the motion for stay was ancillary to that petition, and when the petition was denied, the motion for stay should fall away. But it still comes down to the fact that we have one limited issue here today, which is whether or not the single justice abused his discretion. And then, after a careful review of the party's submission, he reported that he found no likelihood of success on the merits. That ended the inquiry. He gave an explanation. They don't like the explanation, but he gave his explanation. He didn't need to say more. And on the equities and findings that this court made, it's quite apparent there was plenty of support for him making that decision. It wasn't an arbitrary or whimsical determination.
Well, we have to look behind the decision, right? I mean, just because he cites the right legal standard doesn't make it unreviewable.
Right, and I guess to the extent you were to find that there was some grounds for suggesting he abused his discretion, you could rule that way. But I do note the case law says it's the rare case where this panel would second guess the single justice, and this is not that rare case. There's nothing about this case that would warrant finding the single justice abused his discretion here. And if there are no other questions, I'm happy to cede my last 2 minutes.
Thank you very much. Very good argument also. I think we understand the case better after hearing from both of you, so thank you very much.
Thank you so much.
The case is submitted. The next matter is an impounded matter, so I remind the attorneys not to use names of the parties. It is number 25-156, captioned AB versus SS. And we will hear first from Attorney Lawrence.
Good morning, Your Honors, and may it please the Court, Matthew Lawrence on behalf of the appellant A.B. A.B. was last before this Court in January of last year. This Court held that the trial court impermissibly denied an extension of the abuse prevention order. On the hearing after remand in June of 2024, the same judge extended the APO for 6 months, less than the presumptive period of 1 year. In December, the same judge, without explanation, again terminated the APO. This was an error of law. When considering extending an abuse prevention order, the court must first look to the original basis for the order. Chapter 209A has essentially two bases for the order: whether there's a threat of imminent bodily harm or whether there was actual physical or sexual assault. If the original order was based on fear, the trial court must find that the plaintiff continues to have reasonable fear. As this court clarified in Latoya, the case that issued after A.B. was last before this court, if there was attempted or actual physical abuse or involuntary sexual relations, the abuse is the physical harm caused, and a judge may reasonably conclude that there is a continued need for the order because the damage from that physical harm affects the victim even when further attack is not reasonably imminent. The infliction of some wounds may be so traumatic that the passage of time alone does not mitigate the victim's fear of the perpetrator.
Could I, I'm hoping you can help me understand what happened below. There was no testimony. Why was that?
Your Honor, it's very common in restraining order cases that the court will proceed by representations of counsel when both parties are represented. My opposing counsel refers to the Zulu case where the appeals court clarified that these restraining order hearings and abuse prevention order
Shouldn't they stop doing that?
Excuse me?
Shouldn't they stop doing that? Don't you think there should be record evidence in a case in which some kind of injunctive order is issued? I'm not saying it's your fault. The judge said to do it this way, but what the heck is that?
It does cause difficulty, certainly for your honors, in reviewing.
What with there
these.
being no evidence in the record?
Yes.
I mean, it's your client's burden to prove by a preponderance of the evidence that she has a continued need, right? So there's no evidence. So what do? We just take the arguments of counsel as evidence? I don't even see in this record anything explaining the procedural aspects, whether it was the judge that said, let's do it this way, or the parties agree. I mean, what do we do with it?
The court did begin the hearing by asking to hear from me, AB's attorney, and the evidence
You
that
didn't seek to put her on the stand, right? I didn't see anywhere where you said that my client would like to testify, and the judge didn't prevent you from putting her on the stand, right?
No, Your Honor, but I did make an offer of proof, and again, as is very common in the district courts, that the offer was proffered as to what she would testify and what she has testified in the almost 10 hearings she had had before.
But you were satisfied to go forward on representations.
Excuse me?
You were satisfied to go forward on representations.
I was taking the direction from the court, who, in my experience, seemed to prefer to conduct the hearing that way. And the other factor is that as to the evidence that was proffered in AB's offer of proof about the harm she's endured, the psychological and physical effects of the sexual and physical assault, none of SS's proffered testimony rebutted that.
How does he make credibility determinations if they don't get on the stand and testify? I don't understand this at all, to be honest. I mean, I don't understand how we can determine whether your client met her burden of proof when we don't have evidence.
Well, in Latoya, when AB was considering, or when this court was considering the prior hearings, the court focused correctly on some of the concerning remarks made by the judge and his misapplication of the standard, or looking for a standard. And so one of the things we're asking this court to do is that the trial court cannot evade review by simply refusing to hear evidence and refusing to actually make any findings.
Again, I don't see where he said, I'm not going to hear evidence. He said, counsel, I'll hear from you, but he never said, I'm preventing your client from testifying.
That's correct. But again, nothing in the offers of proof, either from myself or sister counsel, none of the elements were challenged. There was no proffer by SS that my client was...
How can it be challenged? How can someone else challenge a representation that they're in fear? I mean, that's...
Well, he attempted to by improperly focusing on events that had happened long before the order was in place, and sort of mischaracterizing some interactions the parties had had long before the order was extended after remand in 2024. So given that there was no offer of proof before the court of anything that would rebut AB's proffered testimony of the ongoing harm.
If she'd actually testified to that effect, the judge could still not credit that testimony. The judge would not be even if it was unrebutted, the judge would not be required to credit that testimony, right?
No, he would not be required to credit it. But again, the judge cannot thereby evade review by refusing to issue any findings or credibility determinations.
Well, the judge can't make any credibility determinations without hearing from any witnesses.
Did the judge ask you to call a witness, your first witness? Because I didn't read that in the transcript.
He did not, Your Honor. He asked me to.
I have to say, I've seen this a bunch before. I've seen cases like this. We have a published opinion that then Chief Justice Green wrote from a few years ago that cautioned judges against using this really nonsensical procedure for a judicial proceeding. And I know your sister hasn't raised this as a basis for, I don't know if it'd be affirmance, reversal, vacatur. I'm not sure what we ought to do with this lurking problem. But, all right.
Did you ask to put on evidence, testimony?
No, I made offers of proof of what my client would testify to, and the court.
I understand that's what you did. Did you ever ask the judge whether you could put your client on the stand?
No, the judge concluded the hearing after each counsel made their representation.
I understand. Did you ever make a request?
No.
Okay.
And Your Honor, that does go to the remedy we're seeking. While we believe the history of this case is lengthy enough and the appeals court's already analyzed it that we believe a reversal would be appropriate, I understand if the court wishes to remand with instructions for findings. We would ask, given the nature of this case, the judge's behavior in this case, that this court would specifically remand it to another trial.
Do we have authority to do that? Can the appeals court order something reassigned?
Yes.
Do you have any cases where we've done that? I mean, we can look it up easily enough, but I'm just trying to figure out if that's a supervisory power such as only the SJC has, or if we can actually do that. I feel like maybe we've done it where there might be an appearance issue or something. I don't remember.
I could not find any cases where the appeals court directly on point could order that, but I believe it would be within the powers of general superintendents.
Okay.
Counsel, so your position is on these representations to the court, you're saying, I believe you stated in your opening, as a matter of law, the judge was required to extend the order based on representations.
I would say that it was an error of law to refuse to extend the order given the history and given the uncontroverted proffered testimony that clearly met the standard as reaffirmed in
Call
Latour.
that an error of law. So based on these representations, you're saying the judge would have been or was required to extend the order. That's your position.
Based on the offer of proof for the testimony, which was uncontroverted, that would have met the standard as reclarified in Latoya, laying out the Callahan
But you
factors.
also just stated that if they actually had, instead of going on representation, if the witnesses had testified and the plaintiff's testimony was uncontradicted, the judge would not be required to accept that testimony.
I suppose the court could make a credibility determination, although that would be difficult, again, given the long history of this case, the instructions from the appeals court in Latoya, that it must accept that the abuse occurred,
Well, it might accept that the abuse occurred, but the judge would not have to credit that these years later that she's still suffering from that abuse.
in the
That was the
abstract,
inquiry, right?
excuse me?
That was the inquiry at this stage, whether that party is still suffering from that abuse.
That was the inquiry, and her answer was yes.
And the judge would not be required to accept that.
If the judge were to make a credibility determination, that would be,
So that's the problem, since there was no witness in order to allow the judge to make the credibility determination. How could the judge have done their job without this, made this credibility determination without you offering a witness?
well, I agree with Justice Rubin that it's certainly a troubling practice in the district court to proceed this way, but it is very common. This is a large part of my
It's also up
practice.
to the lawyers, right? I mean, all the judge said was counsel, and then it was up to you, Judge, I have a witness.
I mean, we don't know, if you say this is the practice of the judge, I don't know how we're supposed to figure that out. Witnesses, the parties are sworn at the beginning. Of course, you do say, my client would testify, which suggests that, to me at least, that you thought the judge wanted to hear that, not the actual testimony. So I don't know. I don't know. Yeah, I don't know what to say about this.
Was your client there, present at the hearing?
She was, Your Honor.
And was sworn.
Yes.
Was
she
anyone sworn for the other side?
Yes,
Well, it says at the beginning of the transcript, parties sworn. I don't know who types that or what happens, but on page 36, I guess, of the appendix, it says at the top, the clerk, both parties step forward, parties sworn.
Oh, party sworn.
No?
Yes, both parties were present and sworn. Again, Your Honors, the proffered testimony was very clearly with the standard that was clarified in her own case. There was nothing controverting that in the proffer from SS. We believe the record and the history of this case is clear enough for a reversal. However, if there is a remand with a decision with findings, again, I renew the request that that be presented to another judge. And if there are no further questions, I yield the balance of my time and rest on the briefs.
I see no further questions. Thank you very much.
Thank you, Your Honors.
We will hear next from, I'm somewhat bad at this. There we are. We will hear next from Attorney Kazmi.
Good morning, Your Honors, and may it please the Court. My name is Noor Kazmi. I represent SS, and just for ease of argument, I will be referring to the parties with their trial court roles, plaintiff and defendant, if that's okay with the Court. Thank you. The trial court did not commit an error of law. It applied the correct standard when it decided to not extend the plaintiff's 209A
How do you
order.
know?
I'm sorry, Your Honor?
How do you know the court applied the correct standard?
Because, Your Honor, the correct standard is, at an extension request, the plaintiff must prove by a preponderance of evidence that the order is still needed in order to protect her
How
from
do you
the
know
likelihood.
that's the standard the judge used? That is the right standard, of course.
Because the judge is not required to articulate the findings if there is a reasonable basis for finding that. And so if the plaintiff is tasked with a burden by a preponderance of evidence, but offers no evidence to meet that burden, I don't believe that a judge is required
I didn't see this argument in your brief.
Yes, Your Honor, it is the burden of the plaintiff.
Is it jurisdictional?
Is what jurisdictional, Your Honor?
This argument you're making, because it wasn't in your brief.
I did make the argument, Your Honor, that the plaintiff is required to prove a continued need, and that she did not do.
You didn't say because she introduced no evidence. I didn't see that at all in your brief.
Yeah, are you arguing that the judge was right to deny it because she didn't put a witness onto the stand, or are you saying that she didn't prove continued need? Which is it?
It's the latter,
Latter,
Your Honor.
okay.
But she did not prove continued need.
And when you say the judge used the correct standard, how do you know that?
Because in the absence of evidence proffered by the plaintiff, I don't believe that there's a reasonable basis for the judge to see that the plaintiff has not met her burden. There's an absence of evidence.
You were counsel in the trial court?
Yes, Your
And
Honor.
were you counsel in this Latoya case?
I was trial counsel, not
So
appeals
here's
counsel.
how I read Latoya, and obviously I'm just one person. I read it to say, well, actually, I'll quote, "The only question for the judge was whether there was a continued need for the order to address the prior abuse, a matter on which he made no finding." And once again, he made no finding of any kind. Don't you think the judge was required to make a finding?
I believe that if you look at the previous instances of this case,
Where
there
the
is-
judge wrongly didn't extend it previously, yes.
No, Your Honor. If you look at for example, the December 1st, 2021 extension hearing, the plaintiff identified a continued need for the order. She told the judge, "Judge, I'm afraid if this order is not extended, he will do what he wants because that's what he does." She told that to the judge, and he extended it. And then again, in January of 2022, she told the judge, "Judge, I'm worried that he's trying to monitor my contact information."
What about the time he didn't extend it and was reversed by a panel of
Because
this
there was
court?
no information offered by the plaintiff.
That's not what the court said. This court, this opinion by Justice Wolahojian, it's a published case, right? And
Yes,
it
Your Honor.
says he was focused on the wrong thing.
It wasn't clear what he was focused on. I would have, had I been appellate counsel, argued perhaps a little bit differently. And here's why. Because, again, if you go back to the December 1st, 2021 case, In the end, the judge is asking the plaintiff questions that are similar as the analysis in IML and Callahan. He's asking the plaintiff about ongoing criminal matters. He's asking the plaintiff about their custody litigation. He's asking the plaintiff what's going on right now. Those are the factors that a court is allowed to consider as the totality of the circumstances. He's asking the plaintiff about that because he's trying to do a totality of the circumstances analysis to determine whether or not the plaintiff still needs the order.
This was
Also,
the
yes.
judge who extended the order in June of 2024? Was it the same judge?
Yes, Your Honor. Yes.
Or until December 2024?
That's correct, Your Honor. And the June 2024 hearing is not before this court. It's the December 2024 hearing, where the plaintiff could have easily offered information as to why this order is still necessary, but
Well,
did
I
not.
thought that, leaving aside the fact that it was done by representation of counsel, which is a serious problem, but leaving that aside, if the judge was considering the representations of counsel, the counsel did say that the plaintiff would testify that she continued to suffer injury from the original abuse, that she continued to seek medical treatment, so she's still having some effects from the abuse. Why do you say that's inadequate?
Because that's not the standard, Your Honor. The standard is to protect her from the likelihood of abuse. That's IML, that's Callahan, that's even stated in Latoya
A
L.
continued need for the order to address the prior abuse. Right? You don't have to show that you're about to be abused again.
No, Your Honor. And that's very clear, that the standard is not to show imminent harm. But there has to be a showing of continued need, why this order is necessary.
So what were the representations regarding why because both parties had an opportunity to make representations. What were the representations as to why there was no need for this order?
Those representations were actually contained in defendant's affidavit, which was submitted. It was part of the record, but not included in the record appendix. So we did submit it as a supplement to the record appendix.
Wait, I'm sorry. Whose affidavit?
The defendant's affidavit.
Well, the defendant isn't. How would the defendant know what the circumstance of the plaintiff is? The question is about the plaintiff's circumstance, isn't it?
Oh, I'm sorry. I thought the question was about the circumstances of the parties.
That was my question. In terms of the totality of the circumstances, what the judge is asking, what's going on between the parties right now? What is the likelihood that there will be continued ongoing conflict of that nature? Is that what the affidavit addresses?
Yes, Your Honor. It talks about how during the time that the restraining order was in place, there were numerous allegations that the plaintiff made, which ultimately were unfounded. Many did not even reach the complaint, the clerk magistrate phase.
I don't think it's for us to figure out what's founded and unfounded. If you read the Latoya opinion, it sounds quite bad. If we read your brief, of course, it sounds quite harmless, right? I mean, we don't know anything about that, actually. I do note that counsel did also say the parties are still involved. They still have a minor child in common that they need to have parenting time exchanges with. Even when this order was not in effect, while it was pending the court of appeals, the probate court judge, knowing the history of this case, still required the parties to exchange at the police station. Now, a reasonable inference from that is that there is some basis for fear on the part of the plaintiff. I assume that's why the lawyer is saying this.
Your Honor, as I noted in my brief, the parties actually came to an agreement to change part of that in the probate court so that the child could do pickups and drop-offs.
Is that in the record?
It's.
Did the judge know that? Or it's out, or you mean since this?
I believe that was during argument on one of the hearings in the trial court, Your Honor, but I cannot point to the record. I would be happy to submit a letter if it's been identified in the record.
No, that's okay. We have the record.
Thank you, Your Honor. But the court is also allowed to consider the party's demeanor outside of court. and that's the RV versus SV case. And the party's demeanor outside of court is also what is explained in defendant's affidavit. There was 2 years, Your Honors, where there was no active order in place, and during that time, plaintiff had no information. She couldn't even offer that the defendant looked at her the wrong way. And as argued in
You think she might have been in fear anyway?
She may have been in fear, Your
She's
Honor.
in fear because of what happened initially, even without a risk of imminent harm. That might be a need for a protective order, right?
It might, but she has to articulate that. For example, in the Callahan case, the court was able to find that plaintiff would have suffered, her sense of security would have been diminished if that order were to expire. And in here, there's no information whatsoever about how plaintiff was affected by there being no restraining order in place for 2 years. And that's also an analysis. So the judge...
That has nothing to do with anything. The judge didn't extend it. It was on appeal. Telling me that there was no more violence during this 2 years doesn't really go to the question. She doesn't have to show an imminent risk of violence.
But that she has to show that her life was affected by there not being an active order in place. And she needs to be protected by this order. Just like in the Callahan case, where her sense of security was diminished. She offered no information.
Maybe I missed the answer. I asked you about the making of a finding, that Latoya seems to require a finding by the judge, and the judge here assiduously avoided making any finding. Any finding. Does the judge not have to make a finding? I understand maybe in some ordinary case, but we already have a decision in this very case saying he has to make a finding.
Again, Your Honor, I would submit that in the absence of any credible information to satisfy plaintiff's burden, I'm not sure what finding that the judge would have to make.
No, there's no need for it.
Isn't that implicit when the judge declines to extend a restraining order, that there's no more need?
Well, I don't know. Since one time, at least, this same judge used the wrong standard, it's not clear to me that it's unnecessary. I don't know. The court said it was necessary last time.
I cannot speak for the trial court judge, except to say that looking at the record, looking at what was offered on December 11th, 2024, the plaintiff did not meet her burden. And even if we accept that the counsel are allowed to offer, make offers of proof, and I would argue that the judge also has had several opportunities to make credibility determinations of the parties, because the judge had not both parties, but the plaintiff had testified before this very judge numerous times. And in these types of cases, when the judge needs information, the judge is free to ask directly of the parties and to inquire of the parties on their own. And in fact, I think that the judge had done this in several different instances, certainly in December of 2021, when he was asking the plaintiff about these factors to determine the totality of the circumstances of the relationship of the parties.
What is it that we're supposed to do in this appeal? We take the representations of counsel as true on both sides and then determine whether, based on those representations, the plaintiff met her burden?
I don't have an objection to taking the representations of counsel, and I say this because, as I cited in my brief, the Zulo case states that these types of hearings, they're sensitive in nature. When you come before the court, there's a whole, seating area full of people. You're talking about the most sensitive, intimate, in this case, an allegation of sexual assault. It can be effective, it can be time efficient for the counsel to make proffers, and then for the judge to ask the questions of the parties directly if there's a credibility issue or if they need additional information in order to make a determination. So I don't think that in every single case we have to have these plaintiffs testifying for those reasons, Your Honor.
So accept the representations of counsel.
I think in this particular circumstance where the judge has already had the opportunity to hear plaintiff several times, and I believe has already made credibility determinations, and those were in the prior hearings, when he made comments such as, I'm struggling to find fear in this, and, trying to explain to the plaintiff the relevance of the questions that she refuses to answer.
Well, I've just looked at the affidavit from your client, and one of its points near the end is, I have never laid hands on the plaintiff and have never taken actions to put her in fear of her physical safety. With that before the judge, how do we know the judge didn't say like, oh, okay, then there's no need for this order at all? There were no findings saying what the judge concluded.
The case law is clear that we cannot relitigate.
That's right, but it was clear before the original time the judge asked about imminent harm.
Again, there's a reasonable basis, there's a discernible basis for the judge's decision, and that's because the plaintiff offered no information to satisfy her burden. She has to relate her fear to the need of the order. She has to state.
So no reasonable judge could have extended this, is your point. As a matter of law, this had to be terminated.
Based on the representations on December 11th, yes.
Okay.
And Your Honor, again, there's numerous instances where we're talking about a credibility determination of the plaintiff, which the judge is also required to make. So under Callahan, the judge also has to conduct a discernible appraisal of the information before it when it's deciding to extend an order. And I'm sorry.
Your time has expired.
Thank you, Your Honors. With that,
If there nothing further?
I do submit on my brief.
Thank you very
Thank
much.
you.
Both of your arguments have been very helpful to us. The case is submitted. The next matter we will hear is also an impounded case. It is number 24898. I am instructed to remind the attorneys and the panel to use pseudonyms for the parties' names, although for some reason that is completely beyond me, it appears that a name appears in the caption of the case. Nonetheless, why don't we use either initials or refer to the individual as the appellant, something like that, so that we don't violate an impoundment order. This is number 24898, and I guess I'll call it in re CB. And we'll hear first, I should have said that bit also, and I should also know, we will hear first from Attorney Beal.
Good morning. May it please the Court. Eric Beal on behalf of the appellant CB. This case involves two statutory elements that are required for a civil commitment to Bridgewater State Hospital. These are additional elements to those normally required for a hospitalization or civil commitment to a DMH facility. I submit that the evidence was insufficient on those two elements and that therefore the commitment order should be vacated. The first of those statutory elements is that Bridgewater must prove beyond a reasonable doubt that the defendant, the respondent, is not a proper subject for treatment at a DMH facility. Typically, evidence that would be presented to show someone was not a proper subject would be a history of elopement, for example. There was no such history here involving CB. Sometimes also evidence is presented that there is a history of substance abuse, such that would raise concerns about contraband entering a DMH facility. Again, no evidence here of such concerns or a substance abuse history with CB. The hospital's theory simply is that if the doctor opines that CB required strict security, that should be sufficient evidence.
An opinion was based on something. It wasn't simply an opinion, it was based on something.
The expert was asked, is there anything about a DMH placement in its access to the community that would be inappropriate for him? And those are really two separate issues. The evidence was uncontested that CB had successfully been treated at DMH facilities in the past without incident, and the doctor conceded that in her testimony. The access to the community is strictly controlled by the Department of Mental Health. They have regulations, they have internal protocols governing who has privileges to leave the campus. And I would direct the court's attention to matter of FA, which I cited in my 16L letter I filed with the court yesterday, in which the Supreme Judicial Court discussed the extensive internal protocols available at DMH facilities. And I would note in that connection also, Your Honors, that the Department of Mental Health and their locked psychiatric facilities, they manage patients every day who are suffering from paranoia or delusions or other forms of mental illness. That's what they do. And if a patient is unable to be treated at a DMH facility, Chapter 123, Section 13 allows the facility superintendent to transfer that patient to Bridgewater. So there's a safety valve. And in this case, there simply was no fact evidence that would have shown beyond a reasonable doubt that CB could not have been hospitalized at a locked psychiatric hospital.
Do you think it's proper for the expert to consider the nature of the charges?
The charges are important, and they're serious charges in this case. The expert may consider them in forming their opinion. The charges are not themselves evidence. They certainly don't prove the truth of the matter alleged. And they also are not, because they're a hearsay, the rules of evidence, apply in civil commitment matters. And so experts are not allowed to improperly bring in hearsay evidence through their testimony. The importance of the criminal charges, Your Honor, really relates to the procedure here. The criminal charges open the door to the hospitalization for evaluation for capacity under Section 15.
Right, but as far as the substance of the charges, can an expert consider the substance, the nature of the charges in reaching an opinion about whether he needs to be committed to the Bridgewater?
Yes, the expert could consider.
They can consider.
The charges are what the allegations are, but those allegations are not facts.
So I thought your position was that proof beyond a reasonable doubt of the need for essentially incarceration at Bridgewater due to risk of harm to others couldn't be based on the mere allegations without sufficient evidence in the record to demonstrate to the judge these allegations actually happened.
That's correct, Your Honor. And that's...
So the expert can take it into account, but the judge then has to have more in front of her or him to say, okay, and those charges are true.
Right. The criminal allegations merely need to be supported by probable cause, and they're not evidence, and they certainly weren't entered here, and they couldn't have been because they're hearsay. Looking at that,
If the petitioner had put the mother, right, the mother on the stand, the victim, she had testified, and the judge then could find beyond a reasonable doubt that the acts occurred, right? I mean, the problem here is that there was no fact witness that was ever put on.
yes, Your Honor, there were no precipient witnesses to testify as to any violent behavior. And this is getting into the second statutory element of Bridgewater's burden to prove beyond a reasonable doubt that failure to hospitalize CB in strict security would result in a likelihood of serious imminent physical harm. And in matter of JP, the Supreme Judicial Court held that the determination of harm is a matter of law for the judge. It's not one susceptible to expert opinion. In fact, the court said expert opinion isn't even necessary. And I submit to the court that if expert opinion is not necessary to show likelihood of harm, it cannot be sufficient by itself. The hospital needs to prove its case. And typically how that's done in these cases is, as Justice Shin noted, to call fact witnesses.
Well, the expert depends what, that doesn't follow that because it's not necessary, it can't be sufficient. Let's say the expert said, well, I've treated this person 8 times in the last 15 years, and it's because of the horrible record of violence that I know of, not just from charges, but from, right, presumably that would be adequate.
Yes, Your Honor. I mean simply opinion evidence in the absence of any factual evidence. Some defendants who are committed to Bridgewater have been found not guilty by reason of insanity, and then there's a factual record of what the crime was and that they've essentially acknowledged the sufficiency of the evidence. In other cases, including the Rosenberg case cited by Bridgewater, again, there is evidence where the defendant was found responsible for murder and kidnapping. There are no such facts here. There are simply the allegations of the criminal complaint and the expert's opinion. And I would also note that where Bridgewater relies on what they assert are the absence of overt facts, or that overt facts are not necessary to be shown. The Rosenberg case is from 1992. I submit it's no longer good law after matter of GP. And matter of GP discussed the definition of harm that's applicable here. Practitioners, we refer to these as prongs. It's the second definition of Chapter 123, Section 1, also called prong 2. And the statute says that there must be evidence of a substantial risk of physical harm to other persons as manifested by evidence of homicidal or other violent behavior. So the plain language of the statute itself requires such evidence. And in matter of GP, the Supreme Judicial Court said regarding that language that the legislature's use of the word homicidal in phrases such as violent behavior signifies an intent that the evidence of conduct reflecting a substantial level of force and intensity be presented. There has to be fact evidence of violence in order to meet that standard. That evidence was lacking here. I would also note that the trial judge appeared to rely on a 58A finding from the criminal proceeding. That, as I argued in my brief, was error. Although the Commonwealth had filed a motion under 58A, a hearing was never actually held on that motion. So to the extent the trial judge relied on a finding of dangerousness, that finding was never made. And I would also note for the court that Bridgewater, its theory of the case really is that there's no requirement to show evidence of violence, and that's on page 37 of their brief. And I hope I've been able to explain to the court that under the plain language of Chapter 123 and the relevant judicial decisions interpreting it, it's Bridgewater's burden to prove violent behavior under prong 2, and that would involve calling witnesses to testify to that. And that didn't happen here.
Is that an amendment to the law, or did it even say it when Rosenberg was decided?
The relevant language under Chapter 123 is, as I understand it, unchanged pretty much from the 1970 Mental Health Act.
Mm-hmm. Okay.
But the law has evolved in that time, and certainly in the last few years for mental health law. I would also note for the court that the evidence was uncontested that CB was behavioral in control. His mood was not a problem. and that he had no incidents from a month in a correctional setting and also nearly 4 months of being observed at Bridgewater State Hospital. And finally, I would note for the court that where the trial judge, CB had testified that he was, at some point, Bridgewater went into lockdown from COVID, and that he was basically confined to his room for 23 hours a day or 22 hours a day. And the trial judge sort of took that evidence and said, well, I wouldn't expect there to be trouble. I just wanted to note for the court that that lockdown did not occur in February when CB was first transferred to Bridgewater. Rather, it occurred, I believe, sometime in March. So to the extent the trial judge was relying on that, I would submit that was also an error. If there are no other questions from the panel, I would rest on my brief.
Okay, thank you very much. Very interesting case. Good
Thank you.
argument. We will hear next from Attorney Conlon.
Members of the panel, may it please the court. My name is Robert Conlon. I represent the Bridgewater State Hospital in connection with this appeal. This case concerns a lower court commitment order of May 27, 2020, which committed CB to Bridgewater State Hospital for up to 6 months as incompetent to stand trial pursuant to Section 16B. On March 22, 2024, the appellate division affirmed the decision. I would ask this court to affirm that decision as well. I did want to note initially that Mr. Beal cited 58A as a basis for the commitment order in this case. On page 40 of my brief, we addressed that. That was not a substantial basis for the opinion or for the decision committing CB to the Bridgewater State Hospital. I would also note that there is not a requirement of violent behavior in order to commit a person to Bridgewater State Hospital. And the site for that, and actually the case that sort of is the progenitor of the GP case, is the Nassar case from 1980, which talks about how the seriousness of prior violence and how that can be factored into an assessment of risk. But initially, I just wanted to note for the court that the appellate division correctly cited the standard in this case. The court reviews the sufficiency of the evidence. We accept the findings of fact made by the hearing judge unless clearly erroneous. However, we review without deference whether the legal standard for civil commitment was met.
So I'm trying to figure out, well, you can tell me. Presumably, in order for someone to be a risk of harm to others, that means there has to be a risk of violence. I guess I can agree with you, it doesn't have to have occurred yet, but there has to be a risk of violence, and that has to be shown beyond a reasonable doubt. Do you agree with that so far?
Yes, Your Honor. Actually, the standard is that it has to be a reasonable, let me just make sure I have the language correct here. Substantial risk of physical harm to other persons is manifested by evidence of homicidal or other violent behavior, or evidence that others are placed in reasonable fear of violent behavior or serious physical harm to them.
Okay, and so now we have an expert opining that is true, that there is a substantial risk of harm to others presented by CB. What is the basis for that judgment that would allow the judge to conclude beyond a reasonable doubt that's right?
Well, Your Honor, it's a number of factors, and it's hard to quantify exactly what a professional doctor considers in terms of their assessment. But in this
they have to there has to be something in the record.
That's correct, Your Honor. And in this case, Dr. Kelly met with CB, interviewed CB, reviewed relevant records, took into consideration that he was facing serious charges in this case that included assault to kill, allegations of strangulation. In the record, CB acknowledges that these are allegations. However, he does acknowledge the allegations. And these factors, Your Honor, basically coincide or are taken into consideration by Dr. Kelly.
Okay, I agree with that. So far, the only violence you've mentioned, although I'm interrupting you, I'm sorry. There may be other acts of violence. The only acts of violence to which, or risk of violence, anything about violence, actually testified to by the doctor is these charges. Is that right?
Well, Your Honor, there are other charges that were factored in by Dr. Kelly in terms of her assessment. The CB had been at Bridgewater a year prior to this commitment, back in 2018, I believe, actually 2 years ahead. And at that time, he was facing criminal charges of a different nature. The charges in this case...
But I didn't see that mentioned in the testimony. It was maybe mentioned that he had been at Bridgewater before, but I didn't see anything about violence. All I saw was highly paranoid, very suspicious, easily triggered, things like that.
Well,
But the fact that the trigger would lead to violence or reasonable fear of violence, all I saw, and I may be wrong, I didn't see anything about the prior charges.
Well, Your Honor, there was a reference to CB being involved in a land dispute, which Dr. Kelly considered an ongoing issue with
A
him.
land dispute.
Yes, a land dispute, and from 1992, Your Honor. And Dr. Kelly had familiarized herself with CB's record through reading prior evaluations, reviewing Bridgewater records.
Are they in the record? Was that stuff introduced to the judge?
Well, Your Honor, there was testimony that he had this fixation over a land dispute dating from 1992 to the present, that had resulted in his involvement with the criminal system. They weren't explicitly testified to because we didn't have that direct testimony, but it went into the opinion of Dr. Kelly that CB, given his present state of mental health, constituted a danger to others. And what's important to
I'm
note, Your
asking
Honor,
you repeatedly, what is the basis for that? You're telling me a land dispute, but there's no record of violence before the judge. I mean, we get people in here, it won't surprise you, who appear to be obsessed with cases from 12 years ago, and God willing, they're not violent, right? So that doesn't really, unless there's charges of violence or evidence of violence, it seems like it's just the charges, and you did mention the charges.
Right.
Can the charges be enough to support an opinion by a doctor and then have it proved to the judge beyond a reasonable doubt when they're just charges?
Yes, Your Honor.
How?
Well, Your Honor, there's probable cause behind the charges.
Probable cause.
Yes. So this is an individual who was in front of the Orange District Court in January 23rd of 2020. He was sent down to Bridgewater at the request of his defense attorney, and this is in the record, for evaluation of his competence to stand trial in connection with these charges. He was held without bail. Dr. Kelly met with him. Dr. Kelly then employed her risk assessment. And Your Honor, commitment isn't about just past violence. It's about future risk of violence. And that, I believe, is cited in my brief, Your Honor. But here, Dr. Kelly, and the Nassar case is directly on point, Your Honor, where it talks about the importance of assessing what the charges are, how they factor into a risk assessment. And in this case, Dr. Kelly noted that CB was displaying symptoms of heightened suspiciousness, sensitivity to threats. He wasn't accepting psychiatric medications, Your Honor. He didn't see a mental health problem. He didn't see that and she said this in the record, Your Honor, page 41. He doesn't see that he is currently having risk factors for violence and therefore is not willing to manage them. There's a precedent to this case, Your Honor, in the sense that, as I mentioned before, CB had been at Bridgewater for several months, I believe in 2018. You only get into Bridgewater if there are criminal connections.
Let's concede that he's mentally ill, seriously mentally ill.
That's correct, Your Honor.
You're still trying to lock him up because of a risk of harm to others. And I'm just not hearing, I'm not saying you couldn't prove it beyond a reasonable doubt. Maybe you could. But you didn't put in any document or any precipient witness or anything, so far as I can tell, that would allow the judge to conclude, oh, these allegations I find beyond a reasonable doubt, they happened. And therefore, I accept the expert's opinion.
That is not required, Your Honor. As the Rosenberg case has been cited, And I believe the JD case, there's no need for recent overt acts of physical violence in order to commit a person.
You just told me there has to be either violence or reasonable fear of violence.
Well, there has to be evidence of it, Your Honor. There doesn't have to be proof of it, absolute proof of it. It's a factor in terms
But they have to, the judge has to find, my concern is just bootstrapping an allegation that hasn't been proven in court or pled guilty to, bootstrapping that into what amounts to incarceration. And I don't see how you can take a probable cause determination and say, oh, with that, I find beyond a reasonable doubt that he is a harm. We don't know if that's the basis of it, past violence, and that does seem to be the basis of the doctor's opinion. I just don't see how you can, without a recipient witness or someone, bring the mom in, bring, any piece of evidence, a photograph taken by the police, like I don't know what the government has, but something, so that a court could find, oh, no, I see this. That's what concerns me.
Well, Your Honor, I believe that case law supports the proposition that the allegations are sufficient at this point in order
Show me a case that where mere allegations are sufficient to put someone in Bridgewater under the statute.
Your Honor, I would refer to my brief on that question. At this point, Your Honor, I did want to note that what was important to Dr. Kelly's risk assessment was the way that CB was presenting. She documented and testified to his presentation as being threatening to others, and that he did not know how to manage these risk factors.
Presentation was threatening to others? Where's that testimony?
Well, as I mentioned before, Your Honor, she noted that he did not have the capability to control his behavior and to manage his risk factors. He doesn't see that he's currently having any risk factors for violence and therefore is not willing to manage them. As I mentioned before, Your Honor, Dr. Kelly was familiar with CB's past by going through Bridgewater records and looking at prior evaluations. The existence of these allegations, Your Honor, again, are a factor that go into her analysis of the case. The fact that he was acutely symptomatic of his illness, not treating for it, had a past record of...
If the doctor had said, and I've treated 42 people with this same constellation of symptoms and same diagnosis, and in my expert opinion, the risk they present is an enormous risk of actual physical violence against people. When I see the paranoid behavior, I know that it doesn't end with, deep frustration, angry letters to the editor. It ends with physical violence. And so even though I don't know if this person had any before, they have a disease that manifests in my expert opinion, physical violence. But there's nothing like that here.
Well, Your Honor, she did testify that in her opinion, he constituted a danger to others at that point, a second-pronged case. The doctor's qualifications are stipulated to. She, had credentials in terms of this type of forensic evaluation. The court credited that, Your Honor, I think for very good reasons. CB did not have an insight to manage his illness at this point. He had been locked down in terms of COVID being a situation at that point, but the record showed that he had been in a strict security setting and that was responsible in light of the fact that he wasn't able to control his own behaviors, that the strict security environment of first the House of Correction and then Bridgewater State Hospital were what were controlling his behaviors and achieving this behavioral stability. It wasn't self-generated. He didn't have insight into his illness. I would note as well, Your Honor, that when CB was asked by his own counsel when he testified at the commitment hearing what his plans were for DMH, a less secure setting, and his statement was that he didn't think he needed to be at DMH.
Well, whatever. He's not an expert. Of course, he'd like to be at his house. Everyone would.
He may not be an expert, Your Honor, but what he offers is, for an expert, very significant in that it shows that he had no wherewithal to control his own behavior. Again, it's mental illness, Your Honor. None of this is voluntary on behalf of CB, but he had history in 2018 of arriving at Bridgewater, being committed to Bridgewater, treating for 3 months with the recommended medications that he was, at this point in 2020, not accepting. He improved and was discharged to a Department of Mental Health facility. So the lower court, Your Honor, and I believe the appellate division, had ample proof to show that the commitment order was rationally based and that there was sufficient evidence for it. And of course, Your Honor, I did want to note that Mr. Beal testified to some dimensions of the Department of Mental Health that aren't in the record, so I'd ask the court to take consideration of that. It was Dr. Kelly who was stipulated to as an expert and had the knowledge of what was appropriate for CB, and given that CB expressed that he didn't believe he required any treatment and would leave a DMH facility, he was a proper subject for commitment to Bridgewater State Hospital. And with that, I just ask that you affirm the decision. Thank you.
Thank you very much. Thank you both. Very helpful arguments. We are going to take our traditional mid-morning break, and we will return in 10 to 15 minutes to hear the remaining 3 cases. Welcome back. We continue our morning with the matter I'm going to refer to as the next matter, which is in fact number 25-0002, Bach v. Shea, and we will hear first from Attorney Rich.
And good morning still, Your Honors. Thank you. May it please the Court, I represent Susan Bach individually and on behalf of the Adams Trust. Your Honor, in many respects, the question as to whether the parties had a present intent to be bound by definitive and complete terms really can be answered from the very first email sent by Mr. Katzenstein on June 7th and the successive responses. And of course, the law calls for the court to address, and this is from the Duff case, the status of things at the time the parties signaled that the agreement had been reached. And that email is in the record as 191. And if I might be so bold as to read from part of that email, Mr. Katzenstein says, "Nice speaking with you. He spoke with his client this afternoon. She noted that Susan had left her a voicemail a while ago asking for, quote, the family photos. At Susan's request, Joan has put aside, quote, the photos, end quote, but she had not responded to Susan due to the ongoing litigation. She would be happy to provide Susan with the photos as part of a settlement." And ultimately, Your Honors, the question here and the issue, and I think the reason why we contend that the agreement at that reached, or the agreement in principle, as I would later say, was reached, is fatally indeterminate, is that at no time did the parties define what was meant by the photos. And as we know from the successive interactions between the parties, that clearly was a point that the parties never had a meeting of the minds, or at worst, there was a mistake as to what the understanding of the photos was.
I didn't see where the first argument was raised to the judge, and that's not how the judge analyzed the case. So why isn't that question waived? It seems like what was argued below was mutual mistake or failure of consideration.
I think, Your Honor, if you look at the brief that we filed, our position was very clear that the parties had did not agree on what was meant and what was going to be supplied, and we took that position. I think the hearing transcript reflects that. I think our brief reflects that.
Hearing transcript seems to be pretty clear that the two issues that were raised were mutual mistake and failure of consideration. When you refer to your brief, you're referring to your opposition to the emergency motion?
Correct, and the motion for reconsideration that followed, yes.
I think we just have the opposition but not the supporting memorandum. So, but when I look at just the opposition, it's 2 pages. Was there a memorandum filed with this, or is this it? This might be. Is there a memorandum that was filed to this 2-page opposition, or is it just the 2-page opposition?
It was simply the opposition, Your Honor.
Okay, so where,
on an emergency basis.
where in it does it say that there wasn't an agreement on the material terms of an agreement?
Your Honor, I think. Well, what we say is that it doesn't dispute, and this is on page 242, Ms. Shea has failed to comply with the settlement by destroying conduct, whether intentional, goes to the very heart of the settlement, such that Ms. Bach is not receiving anything close to the benefit of her bargain. And that, perhaps inartfully, is intended to say that the bargain that she thought that she was reaching, which was to receive the photos, she never received because there was apparently this misapprehension about
Okay, it seems like there's an open factual question lurking here somewhere, and I'll ask opposing counsel about it too. But let's say what was agreed to was what your client asked for in the not responded to phone call or phone calls to the opposing party. And let's say that that means 35 to 40 volumes worth of photographs. Although, of course, there are factual questions about everything, right? About what she might have seen. Were these the ones in the basement? Why did she say this many albums? What, right? I mean, we don't know any of that. But let's assume that we were to assume or say, I don't know if we even can do this, that it was exactly what you're saying, 35 volumes worth of photographs. And let's say, although it wasn't squarely raised in those terms until pretty late in the day, let's say we were to conclude, in the end, that is not what was presented to your client. And so you come in and you say, this agreement, we had an agreement for 35 volumes, and we're being offered 350 or 400, whatever the total number is, photographs. And that, never mind 60 years worth of how many, that's not 30 volumes because each volume holds more than 10 pictures, whatever. Okay, you have some evidence of that.
Yeah.
Why would that render the agreement void rather than just being a breach of the agreement that you can, I think probably still, I don't know about statutes of limitations and so on, you can simply bring that later and get whatever you can get for the breach. And I understand it's, one can argue it's irreparable. You seem to concede that these other ones no longer exist. And so I don't know, all you can get is money damages, I guess. But why isn't that your remedy instead of saying this agreement is now void?
So putting aside for the fact that the argument that because there is this divergence of understanding about what each side was intending to supply, your point is just sue for breach. Walk down to the clerk's office and pay the $300 and file a lawsuit. And I would say under these circumstances where the consideration, assuming that, again, you get beyond the consideration question, is so unique and incapable of being complied with. This isn't I promised to give you $25 and you failed to do so, so file a lawsuit for the $25. I think in this case, and I think there is a basis for the court to conclude that this goes to the essence of what the agreement was, such that the parties should not, that the agreement becomes void. I think that was your language.
Do you have a case that says where money damages would be inadequate to remedy what is clear ex ante is about to be a breach of the agreement, that you can rescind in a way that you can't rescind if money damages would take care of it? I mean, that has some surface appeal to me. I just don't know what the law is, and this can't be the first time someone has said, I'll sell you a piece of real estate and then didn't own it or whatever.
I cannot cite a case to you, but although I will send you a letter under the rule,
No.
I believe that there is authority that says that when the failure to comply goes so to the essence or to the heart of the agreement.
I agree with that, so to the essence. I don't know how one is, and is it an abuse of discretion we're reviewing for? What goes to the essence? It's 350 photographs. I thought I was getting however many. 4,000, or maybe someone will do math and it'll be 1,200 or 10,000. I have no idea. But I got 350 photographs and 10 grand for the charity. How do I figure out what goes to the essence?
Well, I think that it may very well be that this would be something that would have to be remanded to the trial court for factual findings, because of course here the trial court judge made no findings really at all other than to conclude essentially that there was an agreement and that Ms. Bach didn't ask the affirmative question, well, how many photos are there? Those are the only, and therefore it wasn't a mutual mistake. I think those are really the only two facts that she concluded. And, I think on the front end, this issue about whether there was an agreement, I would ask the court to look closely at the timeline. On June 13th, the trial court reached out and said, where are you? Where are you on the settlement? And I didn't respond, we have an agreement, And Mr. Katzenstein was copied, and he didn't respond to my response where I said, we are close to a settlement. We are optimistic. And this is after the court concluded that we had a meeting of the minds. And so, again, not to criticize Mr. Katzenstein, but he could have chimed in and said, oh, no, I beg your pardon, we do have an enforceable agreement. And of course, that was before.
If you had that, then you would have been submitting to the court, you'd be reporting the case settled, right? Even before signatures.
Absolutely, and that happens all the time. And if you look at the cases that the courts will grapple with, they do really focus on, has the case been reported settled to the court? Because even in the absence of a written document, that is a recognition that the parties' discussions are far enough along that they're prepared to say yes. And on June 13th, when the court asked me, or asked both of us, quite frankly, the answer was, we're close, we're not there. Even on June 15th, so now June 20th was the date that Ms. Bach went and looked at the pictures. I wrote to Mr. Katzenstein that Ms. Bach needs to come, quote, come and take a look at the photos before signing. And Mr. Katzenstein, to his credit, wrote back and said, we agree, and by the way, Ms. Bach can't take those photos until she signs the agreement. Again, a recognition, in our view, that the parties' discussions hadn't reached the point where they were ready to announce or declare that we have a meeting of the minds on the core terms. Arguably, counsel could have said, I view the signing of the agreement as a ministerial act, and you can take the photos now. But because we're in this thing where we're trying to decide what are, quote, the photos, our view is that really is the definition of terms that are fatally indeterminate and imperfect negotiations.
You really didn't argue this below. I mean, I'm just not sure what to do about that. You said, in fact, we have an agreement in principle, which I understand might mean we don't have an agreement or might mean we do have an agreement. The judge clearly took it as we have an agreement, and you didn't really argue otherwise below. If you can't raise that now, then what you have is failure of consideration goes to the essence, and I guess mutual mistake, I think you only raised it in your oral argument below or at the hearing below. That's all the judge ruled about. The judge didn't rule about failure of consideration. What do you do with mutual mistake, given that presumably there was no mistake on the part of Ms. Shea?
Yes, however, and we cite the cases, and I'm sure you're familiar with it, that mistake by one party as to the knowledge of the other is the equivalent to mutual mistake in that Century Plastic Corp case.
That's a factual question.
Perhaps it is, but I think here there is no dispute as to the following, which I think would permit the court, if it so desired, to address this as a matter of law from the appeals court. This issue about these albums, there is no question that when Mr. Katzenstein initially reached out, I think this is in his June 17th, he said the photos had been removed from the album and put into a box. It wasn't until, I think, July 2nd that they said, well, actually, there were albums in the basement, they were in bad condition, they were mildewed, and so they have all been thrown out. And
after removing the photos.
Well, that much is...
I'm not saying it's true. I have no idea what's true.
Right.
But you weren't told we threw out full albums because they were mildewed. You were told we threw out the empty albums after we removed the photos from them.
No, there was no reference in that June 17th email that anything had been thrown out. It was the photos were removed from the album and put into a box, and that box would be brought to the lawyer's office. And they knew that the albums had been thrown out. They knew the circumstances, and so what had been disclosed in July had been disclosed to Ms. Bach and to myself early on. It is our position that would have materially changed the scope, tenor, and nature of the discussions.
But weren't you told early on that the photos were in a shoebox?
They were in a box, yeah.
But a shoebox would be kind of small for 4,000.
I don't know. My wife has very big shoe boxes, Your Honor. Got big boots with big... I don't know. But you're right. It did say shoebox. perhaps that should have been a signal to us that maybe there aren't, but ultimately that's why, if you look at the email chain, we said before signing, we need to go and look at them. And Mr. Katzenstein said, come on over to my office, but she can't take them until she signs, which again comes back to this argument. I did just want to note, I think if you go back and read the transcript, I do make this argument that this goes to the essence of the agreement, which, again, perhaps inartfully was my way of saying that there wasn't sufficient intent of the parties in making this argument. Again, I see my time is up, but this was happening on an emergency basis. We did the best we could to present the arguments in as fulsome a manner as we could on, I think it was 2 or 3 days' notice, and so that's why there isn't a detailed memorandum of law. We did give a very detailed affidavit from Ms. Bach, which tried in detail to outline, I think that's an 8 or 9, 10-page affidavit, which really tries to flesh out her perspective about this, which I think is important. But I see I've gone over.
Your time has expired, but if there are more questions, I see none. Thank you very much.
Thank you very much. I appreciate it.
And we will hear from Attorney Katzenstein.
Good morning. May it please the court. Jeff Katzenstein for the defendant and appellee Joan Shea. As the court touched on, the argument that my brother now raises that there was no enforceable settlement agreement was not raised in the court below. In fact, Attorney Rich at the hearing on our motion to enforce the settlement agreement acknowledged to Judge Cloutier that the parties had reached an agreement, and that's in the record.
In principle.
Sure, in principle. And that's reflected in his email, where he states that we have reached the framework of a deal. And of course, that's subject to a fully fleshed out settlement agreement. But that's all that the law requires, that we've agreed on
if the material terms have all been agreed to.
Exactly.
And if the law can supply the others.
Correct, Your Honor. And in that email, Attorney Rich...
What are the material terms about the photos?
How
is that definite?
All that Attorney Rich said in his email, and this was preceded by my email, in which I stated that at Susan's request, Joan had put aside the family photos, and she would be happy to provide them, Susan, with the photos as part of the settlement agreement. And then Attorney Rich responded that the written settlement agreement should include a provision for turnover to Susan of family papers, photographs concerning Richard's side of the family. And that's exactly what we did. We bent over backwards to try to...
So the definite term, in your view, was anything in your client's possession? Is that the definite term? I'm trying to figure out what, because it seems to me, at least now, it seems that each side is articulating a different understanding of what we were talking about. And in fact, my understanding is this started with phone calls in which Ms. Bach left messages referring to the photos, maybe assuming both parties knew exactly what they were talking about. And now, at least it's alleged, there's been no fact-finding, that on the one hand, Ms. Bach had in mind multiple photos from multiple volumes of albums, and on the other hand, that Ms. Shea understood it to be, I don't know if there were multiple volumes, I don't know how, you know what I mean, there's no fact, but understood it to be what she had, which wasn't multiple volumes, it was 50 photographs, and I thought somewhere it mentioned how many albums had been, it doesn't say 6 or 7 or something, maybe I'm making that up. But in any event, if you don't actually have an agreement, how can there be a definite term?
That's a good question, and I think that it was definite enough if you consider the types, categories of photos that existed. There were some photos of just the Shea side of the family with, say, Mr. Shea and Susan and Claire Bach, his sister and Susan's
No, I understand
mother.
that, but now we're at a point where, and I know it came late, but we're at a point where one side is saying there were 30 albums, and I don't think she says 60, 30 to 45 albums, and that I had seen, that everyone knows what I'm talking about, and these photos aren't from it, so they must have been destroyed, which of course I don't really have any idea about. There's no reason, I know nothing either way, right? I'm not saying they were or they weren't. We don't know. But I'm just trying to figure out how it can be a definite term when I don't know what the term is.
Well, even if it were everything in every photograph in her possession that depicted any member of the Shea family, she complied with that.
How about if it were, yes, I understand your position is in her possession. What if, and there's been no trial on this, I'm not purporting to say that either side has done anything wrong, or we have no idea, but let's say there had been 30 to 45 volumes of that side of the family's thing, and hating Ms. Bach because of the lawsuit she was bringing against her and her now late husband, your client had thrown most of them away, which, again, I have no reason, to think that that's the allegation, I take it. So that Ms. Bach thought, it's these, it's not, if she doesn't have them in her possession, I'm still entitled to them. That's what I'm willing to settle the suit for. Do you see what I mean? I just don't understand how, without a hearing about what each of them might have thought, maybe even extrinsic evidence about what there was and so on, I don't see how we can figure out what the term is. Now, maybe it wasn't raised, that's a different...
There were rather detailed affidavits submitted by both Susan and Susan Bach
Hard
and Joan
to judge
Shea.
credibility from typed words.
Well, I think that what Judge Cloutier did, and I acknowledge this was not an express finding of fact, but you look at Susan Bach's basis for this number, 4,608 photos.
I'm not going to look at that. I have no idea who's credible, and I'm not going to make a credibility judgment based on math. And even if the math about numbers is wrong, the number of volumes might not be. You know what I mean?
But Judge Cloutier had the discretion to determine, based on those affidavits, to make that finding of fact. And there is no clear...
That doesn't sound right to me. How can you judge credibility from affidavits? You have to have the witnesses in.
She could base it on what Ms. Bach was basing that figure on, and it was just rough math. It was assuming that Mr. and Mrs. Shea kept every single photo that they kept for 60 years. Her rough math that Mr. Shea took 36 photos at every family event twice per year for 60 years, and then kept every developed photo in albums. That's just an assumption. So,
sorry.
Let me ask you, what was the point of the inspection?
So if you look at the series of emails, the court can see how this goalpost kept getting moved.
Well, wasn't the point of the inspections precisely for that purpose, to make sure that the parties were on the same page?
So Ms. Bach requested the inspection, and we wanted to work and cooperate with her in making sure that she, could look at the photos. We weren't trying to hide anything. And that's why eventually
that inspection served that purpose, to determine whether they were on the same page, and that's whenever they realized they were not.
Well, that first meeting that I met with Ms. Bach, she made no mention of missing photos, any missing photos. And
I thought she repeatedly asked, aren't there more?
She asked, not at that meeting, she asked for documents, additional documents.
Okay, but
at that
she
meeting.
asked, aren't there more? And frankly, your client produced 50 more than 10% more. And then she said, aren't there more? And she produced all of her own side's photos, and it turned out that Ms. Bach wanted wanted some of them, so she was going to get these digital copies at her expense and so forth. I understand she wasn't saying, I thought there were thousands more,
Exactly.
but she was saying I think there are more, surely there are more. Let me ask you this. If someone offers family photos to someone as consideration in a contract, and again, we have no factual findings, and then when they are offered to be given them in order to sign the deal, and only 10% of what they expect shows up, which I'm not saying is there's no fact finding here, I'm just saying, do you think that would go to the essence of the agreement?
If you had actual credible evidence that those photos existed, and you could identify particular photos or a basis for a number of photos, Ms. Bach never even said she saw this volume of photos or
She said she saw 35 to 40 albums that were of her side of the family. I'm not saying it's true or not true. I'm just saying, and that's evidence. You say it's not credible, but no one's ever listened to her story.
If there were specific evidence about what photos were missing, which there aren't in this case, she's just saying she saw albums that she somehow believed to be of her side of the family. She didn't say she looked through them. She hasn't identified particular photos she believes are missing. This is just based on rough math. So this is not.
She's giving up a lawsuit, a pending lawsuit that's about to go to trial. She's giving that up for photos. That was the whole settlement agreement. It was really about the photos, right? So that is the essence of it. And then she finds out that it's not what she expected, and the case had never been reported to. It was, how close to trial was this?
11 days from trial.
Right, and the parties had not reported it settled. Isn't that a strong indicator of whether there was an actual agreement or a meeting of the minds?
Based on Attorney Rich's email to the court that we were very close, and we were, in fact, as the emails reflect, exchanging written drafts of the settlement agreement.
But still not comfortable enough, 10 days away from trial, to submit, to tell the court we're settled.
No, you're right. Each case is different. I felt comfortable with Attorney Rich's assurance that we were so close and, it was unlikely that this would be tried.
Did you ask for an evidentiary hearing with your motion to enforce settlement agreement?
I did not, Your Honor. Judge Cloutier had asked for the parties themselves to be in attendance, but there was no testimony given. But let me also emphasize that these photos, which are supposedly so important to Ms. Bach, and I certainly don't dispute that family photos are important. But if this settlement agreement is invalidated, she gets no photos. So this goes back to trial in Superior Court. The photos aren't even at issue. This is about just money alone. And there are claims and there are counterclaims.
I mean, whatever, she controls her own case.
In fairness to the judge, she didn't know she had to hold an evidentiary hearing on whether there were an agreement because she thought that was undisputed, which she says in her decision, right? But is there a factual question about whether your client destroyed the photos, whether intentionally or not? Because that's what I see in the opposition as their argument.
I think, Your Honor, that goes back to the question of, is there actual evidence beyond Ms. Bach's speculation and her rough math that these photo albums were destroyed?
They've raised the allegation that your client destroyed some of those photos, and there's therefore a failure of consideration because that was at the heart of the settlement. I don't know why you have to make any sort of kind of threshold showing to. They've made the allegation. So why isn't that a factual question that the judge should have resolved?
I think that was a factual question that the judge resolved. It wasn't an express finding of fact, but she incorporated that into her decision that said there was not a mutual mistake. This was a unilateral mistake based on Ms. Bach's unconfirmed assumptions about how many photos there were.
Not mutual mistake, that whether basically the heart of the settlement, that by destroying the photos is the allegation, your client deprived Ms. Bach of the benefit of the bargain.
It's a rescission argument, basically.
I think that under the circumstances, based on the very specious affidavit that Ms. Bach submitted, there was no need for a full evidentiary hearing. There were affidavits submitted, and they were...
I just don't know how a judge is supposed to reject an affidavit. If it were pure speculation, okay, but she says, I saw this many albums, and this isn't enough photos to come from that many albums. And look, you could hold a hearing, and in 20 minutes, less, the judge might find it an incredible story. I don't believe that for a minute, right? Or might find it highly credible, depending on what testimony is offered, right? I mean, to me, I don't know how you can tell whether she's getting the benefit of her bargain without knowing factually what might have been there at the time of Mr. Shea's death.
I understand that, I acknowledge that an evidentiary hearing or specific findings of fact may have been helpful in this case, but it was not required of the trial judge. The trial judge, of course, has discretion to make these decisions in the interest of expediency and managing a crowded docket. So a hearing was held, affidavits were submitted, and she made a determination of uncontested law and finding a conclusion of fact that was not clearly erroneous.
Okay, your time has expired as well. Thank you very much, both of you. It's an interesting and unfortunate case, but certainly interesting. It is submitted. Thank you so much. Our next matter is another impounded case. It is number 24-1353. We will not use any names of the parties, but can refer to people by their title, such as mother, child, and so forth. I gather the appellees are dividing their time with DCF getting 8 minutes and then the children getting 7 minutes. Is that correct? Okay, and we will hear first from Attorney Levin.
Good morning, Your Honors. May it please the Court. Charles Levin, I represent the appellant mother. She's following along today with on the YouTube channel. This case is about a parent who never bought into DCF's theory of the case. It's usually presumed in these cases that the parent will do so, that they'll mold their own behavior to DCF's expectations. And my client refused to do so. She didn't feel that she had a mental illness that affected her ability to raise her children. And I think it's very clear in the record. She verbalized throughout the case that she didn't understand the basis for the removal in the first place. Notwithstanding this, however, she did participate in therapy. She did work with the Department of Mental Health for some period of time, a short time. She did complete parenting classes. She did maintain stable housing. She did maintain jobs. And she had mostly appropriate visits with her children, to whom she constantly espoused how much she was attached and loved her children, that they were everything to her. I would submit that under these facts, the clear and convincing level of proof necessary to sustain the judgments was not met. That because of mother's stability, you look at what the court relied on, they're looking at domestic violence as one big issue, but the domestic violence can't serve as the basis for the judgment when the judge could only find, as he did, that the status of the parents' relationship at trial was uncertain. And both parents were denying any ongoing existence of a romantic relationship.
But they were still in contact.
Still in contact, yes. The court was scared that mother didn't understand the dangerousness of father to her or her children at that time. Father, however, had only charges pending. There was nothing to substantiate them yet, and those pending charges did not involve any behavior towards mother, who in fact testified that she was not scared of him. He'd never physically hurt her. So mother was very outspoken and perhaps paid the price for saying what other parents think but are diplomatic enough not to utter to the department and its agents. She was repeatedly downgraded by the court for her incivility with DCF. In fact, 14 separate findings and conclusions emphasized this behavior. It was a significant, I think we have to say, part of this court's decision and a part of DCF's case, that mother was not able to maintain her composure when it mattered, to provide a summary of it. I think we have to use Zoltan, adoption of Zoltan, as guidance here. While admittedly in this case there were more instances of mother becoming angry with players than there was in Zoltan, I think the principle is the same. In Zoltan, the Supreme Judicial Court stated that mother's anger shed little light on her ability to provide minimally acceptable care to her children. And mother certainly maintains the same thing here. I don't think she denies and never has that she gets angry at DCF. She sees them as a player who unfairly took her children away and never really got over that because she could not buy into their case. A big part of DCF's case and the judge's decision was, of course, mother's mental health. But her last hospitalization was 9 years ago, in 2016. We know that she stopped taking her psychiatric medications during her last pregnancy. We know that she didn't start taking them again afterwards. She maintained that she didn't need them. And this case brings to the fore very closely, I would submit, the care and protection of Bruce, where facts were extremely analogous, dealing with a parent there who had been diagnosed as bipolar. There was an expert treating psychiatrist who testified that as a result of her mental illness that was untreated, her parenting was compromised. This treating physician described her as barely coherent, in massive denial, refusing the very treatment she needed in order to obtain what she wanted, which was the reunification with her children, of course. The court noted that this was a case where DCF characterized it, as they characterized this one, really, as for mother to function well, she needs medication. No medication, no child. But what Bruce reminds us of, because the Supreme Court, Judicial Court didn't buy that, it remanded. It said there wasn't clear and convincing evidence of unfitness. And what Bruce reminds us of is that the clear and convincing standard is a very high standard. I don't think that standard was met here under these facts, even despite a parent who may be in denial about the existence of a mental illness. And
I didn't read your brief to be challenging unfitness. I read your brief to be challenging only whether the unfitness was temporary.
Okay.
Isn't that what your argument is? Because
yes, thank
I'm
you.
looking at your argument, and it says it was an abuse of discretion to conclude that her unfitness would continue into the future.
Yeah, so I concede that my argument fills in blanks or surpasses the argument of my predecessor who wrote the brief. I didn't
Oh, it wasn't
write
your
the
brief, okay.
And I understand that this court is not required to entertain arguments not submitted in the brief, although it has the ability to do so. So I would just ask for a little leeway under the circumstances. You're correct in terms of what the brief does argue.
All right, I mean, in fairness to your opponents, the brief argued what it argued, right?
Yeah. I mean, I understand that. I think it's a difficult situation for my client under these circumstances where I'm appointed late after the brief has been submitted for her and need to put together what I consider to be the strongest oral argument based on that, but I understand that. With regards to that claim for abuse of discretion that mother's unfitness will continue undiminished into the foreseeable future, I would note that mother did show signs of progress manifested in the record in 3 consecutive foster care reviews between February 2022 and February 2023. And the judge's findings addressing the foster care reviews neglected to mention them, which also raises another side issue of the judge passing over positive evidence and failing to review the evidence even-handedly. For example, foster care review of February 1, 2022, which is at Record Appendix Volume 1, page 669, notes that even though the older child experiences some behavioral difficulties, mother is able to manage him well. She makes an effort to provide both children with attention, even though the older ones sometimes demands more of it. She brings activities and is engaged with them throughout. Notes she'd completed her parenting classes and was maintaining stable housing and employment and has support of friends and family. The foster care review of August 26, 2022 notes that the parent caregiver, referring to mother, did participate in the action plan during the foster care review period and, more importantly, more saliently, demonstrated behavioral changes, which is exactly what the courts and certainly DCF are always looking for. The answer to both questions with regards to both children was yes, she did. The foster care review of February 1, 2023 notes that her provider indicated that mother was making progress. Her provider, therapeutic provider, noted that mother was in fact making progress. But the progress in the decision in the judgment was de-emphasized, and mother again was repeatedly downgraded for her incivility. I would say to a significant degree that undermines the authority of that decision. Mothers, I think it's important just to note, this is not an unsophisticated mother. She's a woman with master's degrees from schools in Russia, where she is from. She had experience working a classroom of 12 children, 2 of which had autism, which is the diagnosis of her older child. She went to Fisher College and learned about child development and growth, learned about ADD and ADHD in children 0 to 5. That was uncontested testimony of mothers at the transcript, page 925. And I want to now jump to the second point and again, hopefully fill in some blanks on the brief, which was how mother was prejudiced by ineffective assistance of counsel. And I realize that there's the appellees will claim that it's waived because she didn't file a 60B motion below, but a claim of ineffective assistance may be resolved on direct appeal when the factual basis of the claim appears indisputably on the trial record. I think this is such a case because it's not complicated. This is simply about trial counsel submitted multiple, I believe 6, motions in limine. They're basically mostly carbon copies of each other. They did not indicate any particular excerpt that trial counsel wanted excised.
How can we know if that was indisputably ineffective assistance of counsel without asking counsel why she or he made this decision? Do you see what I mean? The counsel said the whole thing has to come out, right? It contains opinion, evidence, and and lost on that. Maybe there's some reason why specific lines or whatever weren't sought to be struck? Maybe they were cumulative? You know what I mean? I don't know the answer to that.
Well,
But don't we need to hear from counsel why this approach was taken?
Well, I guess in hindsight, maybe that would be nice. I think the fact that that didn't happen does not affect the result here, because no matter what trial counsel said, I think there's a big problem on its face, on the four corners of what he submitted vis-a-vis the evidence that he was ostensibly trying to keep out, because he was ostensibly wanting to keep out the very types of evidence that he would have testified to, if Your Honor is correct, to why he excluded particular excerpts. And that doesn't really follow. I think what he wanted to do was, or she, was to paint with a broad brush, just as the trial judge does himself, by making such rulings that 51As come in to set the stage, 51Bs come in for primary fact. Trial counsel didn't really add to that. Trial counsel was simply saying, you know, we want all of this kept out just sort of because we can, but that's not the rule. The rule is that excerpts have to be specifically delineated, and I think my fellow counsel here agreed with that in their briefs. Yeah, I think that we don't need to either send this back for a 60B motion or exclude it because a 60B motion wasn't filed. I think that the problem is profound on its face. There are many...
I'm sorry, you were talking about the prejudice from this. The briefs from the other side say that there's no real prejudice because the evidence would come in anyway through witnesses.
So I don't think, in cases that's true, but not always true. There is not always duplicative evidence. And I can list some of the non-duplicative evidence for you.
Was it listed in your brief?
No, it was not.
A little odd to have a brief complain that the lawyer didn't identify the actual things to be redacted by not identifying the actual things that should be redacted. I mean, we can look through it, you know, but these are lengthy exhibits.
And another issue I saw was that I didn't see anywhere in the judge's decision where he relied on any inadmissible statements from any of these reports. Because certainly some parts of the reports are admissible, right?
Yes.
Yes, so I didn't see anywhere where he relied on improper opinion or anything like that.
Okay, so I only have 7 seconds left. I wish I had more because there is some.
You can answer the question.
Sorry?
You can answer the question even though the light is red.
Okay, thank you. So I can give you at least a few examples of that. The judge cited these foster care reviews at findings 122, 124, and 130, cited only to the foster care reviews for the findings, and those findings could be objected to based on, under the criteria under adoption of Luke, improper judgment, opinion, or evaluation. There are statements, for example, that mother had not demonstrated mental health stability or appropriate communication skills, anger management. There are statements that she behaved inappropriately, statements that she didn't understand her role due to mental health and decision-making, that she hadn't been fully honest with her clinician. So that's one example, those three findings. There are more, I know my time's up. There are more that I found, just F78 with regards to 51Bs, finding 87, finding 88. And so while I know the judge made a lot of findings and a lot of the evidence was admissible, I think this is one of, it's very hard in these cases because there's so much cumulative evidence, and at what point does the foundation break underneath it all? And this is sort of one of those cases that begs the question. And on my client's behalf, I would urge you to take a look at those findings, look at the statements in those exhibits that do evidence what we would characterize as improper judgment, opinion, evaluation, and make up your own minds whether this decision is sustained. We would urge on behalf of mother to reverse it and remand.
Okay, your time has expired.
Thank you.
If I see no further questions, which I don't, we will thank you very much. We will hear next from Attorney Gallup.
Good afternoon. May it please the court. Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment of the lower court terminating mother's parental rights. There was sufficient evidence presented demonstrating that mother's fitness was more than, her unfitness was more than temporary. Now, I did prepare my brief response to mother's brief, so I don't have an argument to necessarily, I could respond to what was just argued, but in general, I would say that the judge did acknowledge mother's participation in services throughout the life of the case, but the issue was her failure to benefit from those services, which was evidenced not only in her interactions with the department, her interactions with the pre-adoptive parents, but also in her testimony at trial, which the judge had the ability to observe her demeanor and assess the credibility. And it was apparent from her testimony also that she was just unable, so she was non-responsive when she was asked when she stopped taking medication. She refused to answer whether she understood how her mental health impacts the children. From this information, the judge could conclude that despite that ongoing participation with various providers, that she had not benefited from the services such that she could safely care for the children. Also want to highlight a January of 2024 visit where mother became so escalated, the police had to respond, and she barricaded herself in the room, upsetting the children, despite years of mental health services. So there was a nexus that the judge talks about between her poor decision-making, lack of service engagement, and then also her ongoing contact with the father. Now, I could keep talking about that, or I could talk about the ineffective assistance of counsel. I did search for a case to find if there was a case that said failure to designate items in a motion in limine, per se amounts to ineffective assistance of counsel. I could not find such a case. But I did, looking at adoption of Aziza, where in that case, there was ineffective assistance of counsel where the counsel failed to investigate, to talk to witnesses, to actually do more. In this situation, the failure to designate those portions which could or could not be objectionable based on the rules of evidence does not rise to that level. And also there is a case that says the failure to pursue a futile motion does not amount to an ineffective assistance of counsel. So I would say...
It wouldn't have been futile, right? There are certainly parts of the documents that would not be admissible.
There are certain parts of the documents,
what does counsel have to lose by
Pardon?
not? What does counsel have to lose by not designating portions to strike?
I don't know if I really understand your question.
I think the judge is just saying, what reason could a lawyer have for making this a general objection rather than identifying the opinions in it that are to be excluded? Why isn't that on its face unreasonable?
Well, I guess I would say that anecdotally, often you don't even ever see written motions in limine in these cases. So, but I think that in this situation, and I believe that the department identifies in its brief that those potential portions of documents that were objectionable are cumulative, that they were reflected both in the social worker's testimony and in mother's testimony. Information regarding her mental health history, regarding her resistance to acknowledging how that impacts her parenting. That came in through testimony. So whether it was also available in the document, it still came in. And so I would argue that it did not amount to ineffective assistance of counsel on the one hand, but to reach to that second prong, there was no prejudice because this information came in through other avenues.
Can I ask you about something in the briefs? The mother's brief argues that the foster care review reports did not identify the authors. Your brief says they do identify the authors. So I'm looking at one of them, and there's not a signature.
Right.
There's a case reviewer with the name. Is that who the author is?
That's the author of the document.
So it says review panel, case reviewer with a name, and then second party, and then there's also a name. So in all of these foster care reviews, it's the case reviewer who is authoring the report? That's what you're representing?
Correct. That's, I don't know if the second party might be like a community volunteer, but the case reviewer is the person who's running.
Well, there's at the bottom of one of them, I noticed there was a space for any dissenting view.
Correct.
So it must, if there isn't one, it must represent the views of the three members of the panel.
Right, so.
I suppose we don't know which one of them actually wrote it.
No. So the case reviewer is the person who is authoring the report.
What if they're the one with the dissenting view?
I could answer. So when there is a dissenting opinion, and I don't recall from this record if there was in any of these reports.
No, but I'm just.
But when there is, it identifies the person who's providing that dissenting view and what
Well, then in that case, who would have written the majority view if the dissenter is the case reviewer? Which of the other two?
It would still be the case reviewer. The case reviewer
The case
is the
reviewer
person
writes the
tasked.
opinion and the dissent?
Well, the opinion would be reflective of what the panel determined.
Okay.
And then the dissenting view would be, of the panel. Everyone, it's, what is it, 3 people, I think?
Yes.
So, 2 people, this is what they've determined. Dissenting view comes from this person.
Do you think the case
But
reviewer writes it up in every case?
They're assigned with, that's their assignment to draft that
Is there a reg or
document.
something that explains this?
I mean, yes, I don't know which, it's 110C. I could, if the court would like, I can submit a report, letter identifying the regulation.
No, it's a fact, no, we don't need that. Thank you.
So, but also with regard to the family assessments, those documents are authored by the social worker, which is identified at the beginning of the document, signed off by the supervisor. Seeing that my time is almost up, unless there are further questions, the department rests on its brief.
Okay, thank you very much. And we will hear from Attorney Taylor.
Good afternoon. Susan Taylor for the children, the appellee children. May it please the court. I represent 2 children. The youngest child is now 6 years old. He's in the 1st grade, and he has lived with his paternal grandparents, who are the adoptive resource, since birth. The older child is now 8 years old. He is in the 2nd grade. He has severe autism. He is nonverbal. He receives services through Children's Hospital and actually was recently hospitalized. His grandparents, the adoptive resource, have provided him and his brother with safety and stability over the past 6 years.
Can you explain, are you saying that he was hospitalized, meaning placed in a residential hospital setting?
He was briefly hospitalized this past year, yes.
Residentially?
At Children's Hospital.
I don't know what that means. Residentially, that is,
was
rather
inpatient-
than living at the paternal grandparents' house.
No. So he was inpatient at Children's Hospital this past year. I know that's not in the record. I actually,
Well, does it have bearing on whether there is still a pre-adoptive resource or whether?
no, it is not. It does not bear on the commitment of the pre-adopts to.
Yes, but does it bear on DCF's willingness to allow them to adopt?
No.
Okay.
The answer is no. On behalf of the children, I would argue that the trial judge in this case did not abuse his discretion in concluding that the department had proven by clear and convincing evidence that the parents were currently unfit and that unfitness was likely to continue into the indeterminate future, and that the best interests of both of these children was served by terminating parental rights and approving a plan of adoption. This family came to the attention of the department in 2017 when the older child was 2 months old. The family has a history of mental illness, severe mental illness, untreated, domestic violence. Mother, in this case, has been diagnosed as being bipolar and suffering from depression, and she manifests that with aggression towards the grandparents, towards the department. And over the course of the period of time that the mother was involved with the department, she had no less than 10 service plans. And although she has participated in some of her services, she appears to have not made any progress or developed any insight with regard to the children's needs and her role. Even at trial, her testimony was that she submits that her psychiatric hospitalization was not the result of her being mentally ill, but rather that there was a rodent infestation at her house. She alleged that the department had stolen her children and that DCF steals children to sell their organs. Mother had 5 lawyers over the course of this care and protection. And with regard to the ineffective assistance of counsel claim, I would submit that even if you were to assume that counsel should have updated their motions in limine to comply with the court rules, that even if that information came in, the testimony of the mother, the father, and the social worker in this case clearly established the unfitness of the parents. So any of the evidence that my brother is arguing should have been kept out wouldn't have made a difference in the judge's ruling. And in this case, there's an argument that the judge was not even-handed, but the department argued that mother should have no visits with this child, with both children. And instead, the court ordered visits. And I know, once again, outside the record, that the children visited with their mother in August of this year at a visitation center. So on behalf of the children, I would ask that the court affirm the court's ruling, find that the termination of parental rights was appropriate, and the approval of the plan was also.
I know it's not in the record. You've said the older child is in 2nd grade. Is that at this same specialized school that's mentioned in the judge's opinion?
Yes, he is still in the same school in a special class.
This is the, I guess I can say the name, the Kilmer School, is that right?
No, it's a public school that he's enrolled in currently.
Okay. And so nothing residential. The oldest child lives with the paternal grandparents?
Yes.
Okay. I see no further questions. Thank you all very much. These are difficult cases for us, and your assistance with them is really, really appreciated, so thank you. Our final case for this morning is number 25220, Chwastiak versus Goff Cooper. And we will hear first from Attorney Panabianco.
Good afternoon, Your Honors. Attorney Anthony Panabianco on behalf of the plaintiff and appellant, Richard Chwastiak. The primary question before the court is one of jurisdiction and whether or not the actions of the defendants are sufficient enough to convey jurisdiction in Massachusetts. And a little bit of background on the case arises from facts that we understand, at least from the pleadings and the motion to dismiss and affidavits thereof, are not in question. It is the defendant's interference with the contractual relations that the plaintiff has, which form the basis of the plaintiff's complaint. The plaintiff is a disc jockey, a DJ, who operates out of Massachusetts and has, like many DJs, operates everywhere in the world. Essentially, that will allow them and wants them to play. The defendant, one of the defendants, it also has that same profession. One of the defendants also runs a collaboration, XOXO, I believe it's called Shosho, but I will perhaps be corrected on that as to the pronunciation of the defendant's LLC. But they also run in the same circles, and that is how the parties began to know about each other and eventually became friends and lived with each other. But what happened in the interpersonal relationships is almost immaterial for the purposes of this motion to dismiss, so I don't want to go into that unless so asked by the court. What is important here is whether or not the court here in Massachusetts, in Barnstable Superior Court, has jurisdiction over the defendants. And we argue that it does, and that the court erred in concluding in their motion to dismiss, in granting the defendant's motion to dismiss. In our opinion, there is personal jurisdiction over an out-of-state defendant such as alleged here. The defendants allege that they both currently reside in Scotland, though the actions of both defendants showcase that for many years, going back all the way through from the birth of one of the parties up until the present day, that they have had significant and ongoing relationship with the Commonwealth. And under those considerations, both under the long-arm statute, under both Sections A, Section C, and Section D, that the defendants
You don't mention Section D in your brief, do you?
No, we don't mention Section D in our brief, though we do mention the long-arm statute at sec in our brief. And Section D is relative to causing tortious injury in this Commonwealth by an act outside of the Commonwealth for anyone that engages in a persistent course of conduct. We, of course, go into great detail in our opposition to their motion to dismiss that there is a persistent course of conduct by the defendants here in the Commonwealth. And in their motion to dismiss, they go into great detail in their affidavits as to what they have done or have not done in the Commonwealth. So I think this court, it is appropriate to look at both AC and D in the course of what has transpired in the opposition, the affidavit submitted, because the court considered that as well. So I think it's appropriate for this court to also consider Section D relative to the persistent course of conduct.
Well, why don't we look at A and C first and see where we are with them?
Sure. For Section A, it is whether personal, private, or commercial under Ross v. Ross, and is to be construed broadly. We cite that in the Bond Leather case. And when I say construed broadly, there are a multitude of cases that have small, some might say, or limited interactions within the Commonwealth that would thus convey jurisdiction, confer jurisdiction to the Commonwealth.
Let's look at the text of the statute.
Pardon?
Let's look at the text of Section 3. It doesn't just say that there's personal jurisdiction over anyone who transacts any business in the Commonwealth. It says the personal jurisdiction is over a cause of action arising from the persons transacting any business in the Commonwealth. Now, maybe you've made the case that one of these people derived $300 from an act of I don't remember, maybe it was being a DJ or some event here, and maybe you've made the case that the other person attended some kind of either jointly advertised or produced event one time in Massachusetts where they say they were attending just as a spectator, but maybe there's some inference that it was part of their ongoing business. The cause of action didn't arise from either of those things, right?
Respectfully, Your Honor, I think they are causally related to those causes of action.
The causes of action are for defamation?
Yes, because it is based within what they all do for a living, which is within the DJ and music world. So I think it is all related in that causally connection. There wouldn't be a cause of action for defamation or...
Can you move the mic closer to yourself? I'm having a little bit of a hard time.
There wouldn't be a cause of action for defamation or interference with contractual relations if there wasn't already that relationship that they're within the same business arena.
Great.
Your Honor.
But there would be a cause of action even if they hadn't done the one gig in Massachusetts, wouldn't there? It's got nothing to do with the gigs, these two gigs in Massachusetts at all.
Respectfully, I disagree, Your Honor. Well, I don't think it matters for the purposes of whether or not jurisdiction can be conferred over to the defendants. I do think that those causes of actions, the causes of action complained of in the complaint, are related to the overall actions of the defendants in Massachusetts. It is attempting to, as noted in our paperwork, Mr. Trostiak didn't perform for about 4 years due to the pandemic. When he started up again, his immediate first steps was an event in Berlin. And the defendants sought to restrain Mr. Trostiak from returning to promoting himself and being able to provide a living, which would directly impact the ability of the defendants themselves to perform, whether, albeit here or elsewhere, and they are the ones throughout.
I'm sorry, I don't understand what that has to do at all with these two gigs. I fully agree with you that the allegation is, as you describe, about an event in Berlin. I have no idea why it would be that if they hadn't done this one gig in Massachusetts years before, or whenever it was, even recently, why the cause of action wouldn't be the same. It arose from actions maybe taken in Brooklyn, maybe taken in Berlin or Scotland, I don't know, but it doesn't look like it arose from these isolated pieces of, let's call them business in Massachusetts.
Respectfully, I disagree, Your Honor. Those causes of actions were immediately prior of the context within the Commonwealth to the cause of action.
How does the Commonwealth event give rise to it? Did they mention it at the Commonwealth event?
Sorry, say that again.
Did they mention how bad your client allegedly is at the Commonwealth event?
No, not.
Okay.
No,
did the Commonwealth event give them a new platform in which to announce to the world, because they'd been here in the Commonwealth, something about your client?
Yes, Your Honor. If you look at it in the sense of Mr. Trostiak beginning to perform again in 2023, which will include and does include the Commonwealth of Massachusetts. If not for their...
I'm willing to say he's injured in the Commonwealth. He seems to live here, or did. Okay, but it has to arise from the defendants' acts in the Commonwealth.
Yes, and the defendants if you're looking just at 3A, which is not the exclusivity of what is required here, there are other sections that can confer jurisdiction, but with 3A, if you're just looking to the interactions within the Commonwealth, it wouldn't be but for those actions of them promoting themselves to exclude acts like Mr. Chwasiak that give rise to the cause of action. If they did not promote themselves or provide entertainment here in the Commonwealth to the detriment of Mr. Chwasiak, which is what the alleged harm is that they're trying to make it so that any action that he has could not move forward. Those are the injuries that are caused to my client. Therefore, it is related to what they do. If they were an independent company, perhaps that weren't doing an identical issuance of competing acts here in the Commonwealth, it might be a different story, Your Honor. But it is those within those acts and their desire and actually having it happen of preventing Mr. Chwasiak from performing and knowing that he lives in Massachusetts, ability to create a livelihood with that fear, whether the injuries are sustained here.
Did they outcompete him for either of these gigs? And did they do so by alleging that he was unfriendly to the community?
Not for the gigs that
ones in Massachusetts.
Yeah, the ones in Massachusetts. Not for those. There's no assertion to that at this time, Your Honor. That's not in the evidence. But that's only as it relates to Section 3A, Your Honor.
Mm-hmm.
If we look at the totality, and I know that there's some discussion of whether or not the evidence in and of itself is sufficient, we look at just the defendant's affidavits to demonstrate their contacts with Massachusetts that would be sufficient to survive a motion to dismiss. It is not just...
Under which subparagraph?
Pardon?
Under which subparagraph of Section 3? We're leaving aside A now, right?
C or D, I think, is we can.
There was an act or omission in the Commonwealth.
Yeah, an act. Section D would be an act or omission outside of the Commonwealth.
Yes.
If they
then you have to show that they regularly do or solicit business, persistent course of conduct, substantial revenue. I don't know what DJs make. I hope $300 isn't substantial revenue.
And if I may, Your Honor,
yeah.
The Section D, all the language there is or. It is not that all of those conditions are met. It's whether.
No, I agree with that. So now we have to regularly does business. You've shown one event for each of them. Solicits business. All right, we'll have to talk about that. Or engages in a persistent course of conduct, which it doesn't seem like they've done in Massachusetts based on these isolated events.
And it comes down to that regularly solicits, Your Honor.
Okay.
If you look at the affidavits submitted by the defendants and the facts contained therein, XOXANYC.com there promotes worldwide, but also promotes here in Massachusetts. Ibanez's LinkedIn does so as well. A print interview in which Ibanez, in their own words, state that they are home to 11 residents based in Brooklyn, Boston, Pittsburgh, and Miami. An interview that they had acknowledged having done that acknowledges that. An April 8th, 2023 post in which Ibanez stated that its East Coast tour is to begin. So if you live in Baltimore, Boston, Philly, to make a sign for it. The social media page that showcases videos from those attended parties, and one of their preeminent on XOX, one of their preeminent DJs that they are promoting is a Boston-based DJ, as they note there. That is persistent, Your Honor. That is consistent throughout multiple media formats, multiple conversations in which they are consistently promoting themselves to having accessibility and performing here in the Commonwealth. So that in and of itself is sufficient to confer under Section D, the substantial, persistent, solicits business regularly. That is more than regular, Your Honor. That is consistent throughout the entirety of the case and the entirety of the relevant period. I will take additional questions if you have any. If not, I will note that it is our request that this court remand it down to the Superior Court, and we survive the motion to dismiss as and reverse the judgment.
Okay, thank you very much.
Thank you so much.
We will hear next from Attorney Maxson.
Good morning, Your Honor. May it please the Court. Taylor Maxson on behalf of the appellees. Your Honor, under the long-arm statute, Chwasiak had to prove that the Commonwealth courts had specific personal jurisdiction over the appellees, Gao Cooper and Ibanez. It is clear that they do not, that this plaintiff could not establish specific personal jurisdiction. And based on Justice Rubin's questions, we are getting at the same points here. These are the sporadic instances of transactions of business that occurred most recently in 2019 for each of these defendants are simply not sufficient to establish that Ibanez and Gao Cooper were transacting business within the Commonwealth or in any way causing tortious injury by an act that they committed in the Commonwealth. Because again, the statute requires that the cause of action arise from these two prongs under Chapter 223A, Section 3. I would point out for the record that in Mr. Chwasiak's brief, he does not raise Section 3D, and that argument is waived. In looking at the facts and circumstances here, Ibanez and Gao Cooper reside in Scotland. They have not resided in, Gao Cooper has not resided in the United States since 2020. And Ibanez has been living split between New York and Scotland since 2020 and residing full-time in Scotland since 2023. Most certainly, this does not suffice under the long-arm statute. And I would point the court's attention to two cases in particular, Marino v. Hyatt, a First Circuit decision, as well as the Tatro case by the SJC regarding those issues. Further, any evidence that has been presented by Mr. Chwasiak to try and establish the contacts within the Commonwealth that he relies on to make these claims against them are simply, it's all inadmissible evidence. The evidence that has been put forth is not supported by an affidavit to authenticate it, and the items suggested as the other basis for these contacts are not self-authenticating in any way. So for these reasons, the evidence that is before the court cannot be relied on. And even further, there's layers of hearsay, and there has not been explained any exceptions to the hearsay rule that would somehow make this evidence admissible under the 801D. Finally, even considering the due process requirements here, the due process requirements in order for specific personal jurisdiction to extend to Gao Cooper and Ibanez. Again, this is just not met, and it's similar to the same context that can't be established under 223A, Section 3. Again, there are no minimum contexts that show that Ibanez and Gao Cooper, have purposefully availed themselves to the laws of the Commonwealth in any way. Further, there is just simply no indication that the cause of action, which is an email sent from Scotland to Germany, arose from these minimum contexts, and it would not be reasonable under the Gestalt factors to extend this court's specific personal jurisdiction to Gao Cooper and the defendant, to Gao Cooper and Ibanez. I am certainly happy to answer any of the court's questions, any questions the court may have, but otherwise I would rest on my brief and ask this court to affirm the decision of the Superior Court judge.
I see no further questions. Thank you very much.
Thank you.
Thank you both. With that, the case is submitted. this brings us to the end of our sitting for today. I'd like to thank the court officer and the court staff for their very helpful assistance. And with that, we stand in recess.